Good morning, everyone. My name is Andrew Buckham. Welcome to the Irwin Mitchell Military Annual Conference. It's an event that we hold every year. I'm grateful for everybody for joining today. I'm a partner in the Irwin Mitchell Military Southampton team, and the purpose of the conference today is to look at a wide range of issues, particularly in relation to initiative and campaigns that have changed the military for the better in some way, shape or form. And this was a particular theme that we wanted to look at this year. Irwin Mitchell has always been at the forefront in relation to these types of campaigns, whether it be through the Armed Forces Compensation Scheme, to campaigning on behalf of families in relation to inquests. So we have quite a broad range of speakers dealing with these issues, and I'm very grateful for each of those speakers coming forward. So you'll hear from Kim Jackson, who is an Associate Solicitor at Irwin Mitchell, who will talk about AFCS. Caroline from the charity Inquests, Kate Parkin, who will talk about the NHS and the interlink between the military and the NHS, particularly from the work that she does with the NHS Sussex Trust, Dr. Charlotte Herriot and Professor Matt Fossey, who are going to talk about violence, sexual violence within the context of the military community, and then Craig Jones, who's been kind enough to come forward and talk about the great work that Fighting with Pride have been doing. So we've got quite a packed schedule there for you. There'll be a couple of breaks in between, and we'll also have the opportunity to put questions to each of the speakers. So absolutely feel free in the chat to put those questions forward, and then we can make sure that those are asked. If there are any questions that we don't get to cover, we're going to produce a document at the end, which hopefully then will be made available online so you can see the kind of issues and questions that we'll put forward. We're also on social media, so if you want to go onto Twitter, then if you want to use the hashtag against the odds, then that would be great. And at the end, there'll be a feedback sheet for you to complete as well. So without further ado, I'm going to introduce Kimberly Jackson, who, as I said, is an Associate Solicitor within the Armed Forces Compensation Team in Manchester. The AFCS world is something that Irwin Mitchell have been engaged with for a number of years, going back to 2006 when we supported Ben Parkinson and his mum Diane in relation to the campaign that they put forward to try and force through AFCS improved compensation benefits, something they were very successful with. Over the years, the AFCS system has had its trials and tribulations, and Kim is an assistant solicitor who pushes through those particular cases. So Kim, if I can hand over to you.
Morning. Thanks, Andy. Hi, everyone. Thank you for joining us today. So as Andy kindly introduced, I'm Kimberly Jackson, and I'm an Associate Solicitor in the military team, specialising in the Armed Forces Compensation Scheme. So I'm going to give a short presentation today on a basic introduction to tribunals. Quite often we do have inquiries coming to us at this stage. Now this stage is the very last in terms of their claim and the process that they've been through. It can quite often be too late for us to get involved at this particular stage, as we won't have yet had a chance to sort of consider and evidence gather on a client's behalf. So I thought it would be useful for setting out some simple practical considerations for anybody who might be going through the process on their own. So just by way of background, what we do as solicitors here, so we assist veterans and serving personnel in their AFCS claims. Our role is to assess merits in a client's case, gather the evidence and run the matter through to representation at tribunal if needed. Here we at Irwin Mitchell will only take on a case if we can add significant value. So we only actually take on about 6% of claims. A lot of inquiries that come to us, we can just let them know what's needed so that they can take the matter forward on their own behalf. As I said, sometimes it can be a bit too late for us to become involved, but we do give pointers and advice on what would be needed. We're more than happy to do that at any stage, but our advice is primarily always to get in touch as soon as possible. Basically, the better the evidence at the outset, the more chance there is of securing the right result the first time round, and hopefully potentially avoiding the need for a tribunal in the first place. So that's something that is obviously always preferable, because as with any sort of court or tribunal hearing or legal matter, there's always litigation risk that needs to be accounted for on the day. So I've just set out here, just in simple terms, the scheme. The process is triggered obviously by the client filling in an application form and submitting it to Veterans UK. If that first decision is incorrect, then they will have 1 year to challenge it, and that's known as a reconsideration. If that reconsideration is still wrong, then there's a further year to appeal. So that's when you'd appeal to an independent tribunal. And your case would be heard in front of 3 panel members, so 1 legal, 1 medical, and 1 military. On the next slide, I've just put here the listing process. So the appeals process begins when a client lodges a formal notice of appeal, setting out the grounds. Okay, so from here, the process is kick-started. Veterans UK would issue to the client a copy of the response bundle, and these are the documents that form the basis of and contain the evidence for the hearing in front of the tribunal panel. So once the tribunal are in receipt of this, they will then generate the listing questionnaire. So I've just put a screenshot here of the listing questionnaire. So that's the first thing that you'll get through from the tribunal. Ideally, at this stage, all of your evidence should now be contained within that bundle. And so if it's not, which is quite often the case, this is the start of a process which needs to be carefully managed. Now, the important thing to note here, and that we always tell clients, is that this is your hearing and you can control the process. So even if you're not ready at this stage, when the listing questionnaires come to you, I'd still complete it, but you need to make your position very clear with the tribunal. Fill in the form with your preferences. So you'll see here that there's a question about, whether you'd rather have the hearing virtually or whether you'd have it in person. Clients quite often ask us what's best. I mean, it makes no odds really in terms of how the case is dealt with. Your case will be dealt with in exactly the same way, but some clients have a preference maybe to, sort of have their day heard in court, or they might feel more comfortable because of the symptoms or injuries to have it at home. So it's entirely up to the individual. I'd say to clients, if you want to have someone with you there for support if needed, that's absolutely fine. You just need to let the tribunal know who'll be attending. If you've taken witness evidence from a loved one, from family members, partners, then you might want to have them there too if available. Sometimes the panel like to ask them questions. It's not always the case, but it could be of assistance if you struggle to sort of give information. What I wouldn't recommend, however, is not attending the tribunal. So there is a question there whether if you would be happy basically for the hearing to go ahead on the papers if you're unable to attend. We wouldn't really say that's appropriate. As we said, it's your case, so really you should be there to sort of answer questions and know what's happening. Regarding the dates for availability, obviously this will depend at what stage you're at, but if you're ready to have your case heard, you can ask the tribunal to let you know the dates that they're listing on. Instead of having that to and fro with them, it just prevents the need for any adjournment. It can just be a lot smoother and quicker. So if you're not ready to list, then you might not want to put a date in now, but as I said, you do need to let the tribunal know where you're up to. So on the next slide, I've put up some considerations at the point of listing. So once you've received this questionnaire. So I've just set out here the burden of proof. So in law, when we talk about the burden of proof is on the client to ensure that all of the necessary evidence is within the papers to support your case. So therefore, don't assume that the bundle of papers will already include all of your evidence. It's the client's responsibility. The difficulty that we have is that quite a lot of the time when clients do come to us, they will know that Veterans UK will have gathered the notes, but they won't really understand that actually the burden's on them to sort of make sure that everything is there that's needed. So by way of background, and just to have this in your mind, the way that the scheme works, a lot of you might already know, is that it does work on a tariff-based system. And so essentially what this means is that the scheme is broken up into a series of tables with descriptions, which are known as descriptors, and each of these descriptors equates to an award. So say for instance in your appeal, if you're dealing with the value of a case, the tribunal would therefore be effectively considering which descriptor best fits your injury. So when you're looking at that, considerations that you need to have a think about are whether you've reached a final prognosis, whether you've satisfied the definitions required by the tariff descriptors of the scheme, if you have all of the necessary evidence to support that. If you've got multiple claims, do any of these need to be heard together, potentially because of overlapping symptoms? And is all of your supportive evidence contained within the response bundle? If the answer is no, then you need to consider whether in fact your hearing needs to be placed on hold, pending the outcome of any of the above. If yes, then obviously you can complete the questionnaire and ask them to advise you of the next available dates for listing. On the next slide, I've just set out here the overriding objective. So apologies, this is a bit wordy. I've put a link there to basically the war pensions and tribunal rules. So when the tribunal are considering your case, they obviously have these rules that they work by. Now, the overriding objective of these rules is to enable the tribunal to deal with cases fairly and justly. So it says that when they're dealing with a case fairly and justly, that will include dealing with a case in ways which are proportionate to the importance of the case, the complexity of the issues, the anticipated costs, and the resources of the parties. They will, so far as possible, avoid unnecessary formality and seek flexibility in the proceedings. But the important part here as well is that they want to ensure, so far as practicable, that all parties are able to participate fully in the proceedings. The reason why I sort of set that out, so if we just move to the next slide. The reason why I set that out is because if you're not ready to have your case heard, then basically you need to use the overriding objective to your advantage. So for instance, if you know that your prognosis is unknown and you therefore can't meet the definitions required, which I'll come on to later, then you'll need to ask for your case to be placed on hold. And so it's really useful to be able to quote that overriding objective where you can. So if the tribunal are on full notice and you've set everything out very clearly, then it would be very difficult for them to progress to a hearing without the relevant issues that you've raised being addressed first. So if you're asking them to put it on hold, I'd give them full reasons, give them as much as possible and quote the criteria. So I've just placed there, I won't read it out, but I've placed there the standard wording. So what's really important is that, say for instance, you haven't been able to complete treatment, that would essentially mean that it might bar you potentially from getting the higher descriptors, which in turn would mean that you're not able to participate fully in the proceedings. So you're basically quoting that and asking that that be taken into consideration in order to have your case dealt with fairly and justly. So moving on to the next slide. Looking at evidence, as I said, so you're wanting to consider whether you've got all of the necessary evidence. When clients come to us and they've been handling their appeal for some time, quite often they won't actually know or understand what the actual point of the appeal is. So they might just understand that Veterans UK haven't given them the award that they need, or they might just understand that Veterans UK are rejecting their award. What is really important is that you find out what the specific point of the appeal is. So there are two parts to an AFCS claim. The first is eligibility. So this is basically showing that your injury was caused by service after 2005, which is what makes you eligible to claim under the scheme. So for instance, Veterans UK might be disputing that you were taking part in a particular MOD approved sporting event or something similar. If that's the case, then you need evidence to support that you were taking part in an MOD approved sporting event. So you'll have to consider what sort of evidence you can gather to support that. So say for instance, you know, have you got any chronologies that you can put together? Can you get together any specific dates and times? Can that be backed up by witnesses? Have you got any emails, Part 1 orders? You'll need to have a think about where that documentary proof can be found. If you're looking at quantum, which is the second part, so once eligibility has been established, then you'll look into quantum, which is the value of the case. So have Veterans UK given you the right tariff descriptor? I've just put a small screenshot here because if you are struggling sort of getting the information out from the letters, I know it can be confusing because sometimes letters can contain all of the information that's led Veterans UK to the decision that they have, but you might not necessarily be able to see very clearly what it is that is the actual point of dispute. once you've got your response bundle, your bundle of papers, if you turn a few pages in, there's a small paragraph there that says summary of issues for determination, and that is what the specific point of the appeal is. So here it says that the appeal lies against the Secretary of State's decision that placed the condition PTSD at Table 3, Item 3, Tariff Level 10 of the scheme. So what that means is that Veterans UK are effectively challenging, whether the decision that Veterans UK gave is correct. Now, it's important to note that if that is the issue, that is the only issue that the Tribunal are considering on the day of your hearing. They can't consider anything outside of that. So on the next slide, I've just set out the PTSD descriptors. So in terms of quantum and going back to value, say for instance that the specified point of the appeal is the level to be awarded and you have got the level 10. Now you'd have to have a look at the tariff descriptors that appear above the award that you've received. So for instance, above a level 10, you will have a level 8 and a level 6 award. So with respect to the wording, they look quite similar. They both contain the word permanent and they both contain the words functional limitation or restriction. The difference between these two descriptors, is that one is severe and one is moderate. Now, what you have to understand is that although it says the word permanent, it's not permanent in the same sense that we might know it to be. It is defined within the scheme. And when you break down that definition, there's 4 different parts to it. So what you need to be able to show and evidence is that to meet permanent, you've had appropriate clinical management of adequate duration, your injury has reached a steady or stable state at maximum medical improvement, and no further improvement is expected. So for the first half of this descriptor, you'll need to consider whether the medical evidence within your file of papers shows that that definition has been satisfied as required by the descriptor. What you'll also need to think about is whether actually all of your notes are within the response bundle. So although Veterans UK have written out for your notes, it might be that there's particular treatment notes missing. That goes to the heart of the definition of permanent. So it would be important that if you can get those, that those be within the response bundle. Now, it might be that the notes that you have don't necessarily show that you meet that definition. So you might need to consider further whether you need medical, independent medical evidence or evidence from your treating consultant to show that you satisfy those parts, and in order to make it very clear to the tribunal that the issue is being addressed. So if we move on to the next slide and looking at the second half of the descriptor, which relates to functional limitation or restriction, severe and moderate are set out within the footnotes to that table of injuries. So again, there's further definitions that need to be considered. So it's wordy again, so I do apologise. I've tried to set it out so you can sort of see the difference. Severe is where you're unable to undertake work appropriate to experience, qualifications and skills at the time of onset of the illness, and over time able to work only in less demanding jobs. So the difference there between severe and moderate is that with moderate, you're able to work regularly in a less demanding job. But the important thing to note here is that you are having to make the comparison with what your work was at the time of the onset of the illness. So at the time you sustained, if obviously looking at mental health, at the time you sustained your mental health injuries. So it's really important that, again, that comparison is within the evidence that you've got. If it's something that's not been addressed, then you'll need to have a look and see, whether a witness statement from you might help, or whether a witness statement from a loved one might assist. So sometimes we do get family members, partners, wives and husbands to comment. Sometimes it is easier for them to be able to draw that distinction. We do ask them to comment, on symptoms, things like that feed into and paint the overall picture of PTSD, but it's really important that you do address your mind to those specific issues. So over on the next slide, I've just put here the standard of proof. So the reason why I've included this is because you might have heard of legal tests in terms of beyond reasonable doubt. For the Armed Forces Compensation Scheme, The relevant legal test is on the balance of probabilities. So what that really means is more likely than not. I point that out because if you're going to write off to a treating consultant or you're going to get independent medical evidence, say for instance you wanted to ask that expert whether your injury was predominantly caused by service after 2005, which is what's needed for the scheme, you would be asking them on the balance of probabilities. So you would need to say to them, on the balance of probabilities, was my injury caused by service after 2005? Obviously it's a bit of a lesser burden, so it's something to take into account. We do draw the distinction here as well with war pensions. War pensions was a scheme that applies to injuries pre-2005, and they are two very different legal tests. So for war pensions, the test is attributable to service. So your case will be deemed to be attributable to service for the purposes of that scheme, unless there is positive proof that it isn't. Under AFCS, your case will be treated as not being caused by service unless there is positive proof that it is. So over to the next slide, please. So once you've gathered all of your evidence and you feel that you've got everything that you need, or you've managed to get everything that you can, you'll need to submit that to Veterans UK and the Tribunal, and you'd need to ask Veterans UK to prepare a supplementary response bundle. Now, what I would say is that when you're sending that evidence to the Tribunal, always send it to Veterans UK and the Tribunal. It would probably also be worthwhile asking the Tribunal if they could make a direction or basically ask Veterans UK to prepare that response bundle within a set amount of time. It just prevents the matter from sort of going on and on. Now, you will have to set a realistic time frame. So what you have to bear in mind is the volume of documents. When you're sending that over, the case handler has to be able to review that. They have to send that to the medical advisor. It then has to go back to the case handler and they have to prepare the response bundle. So say, for instance, something like 3 months might be a realistic time for them to comply. Once you have that bundle, you're now ready to proceed to have your case listed. And that's when you can sort of ask the Tribunal for dates of availability. Our best advice for the hearing on the day, when you're in front of the Tribunal, is to answer the question that's being asked of you. You can always ask for breaks if needed, and you should ask to clarify if you don't understand. So if we go back to the point of it's your hearing, I know it probably doesn't feel like it, but a Tribunal is actually more informal than a court hearing, for instance. So they are well equipped and they're used to dealing with clients who, might have significant injuries that make them vulnerable. They might have mental health conditions such as PTSD. They might have a brain injury. They're more than happy to make adaptations for that as you go along. So if there's anything that you want, I would just ask them. You can ask them before the hearing. And if it's something that helps you set your mind at ease, then obviously it's worthwhile doing. Just over on the next slide, I've just put decisions. So if you're not happy with an outcome from the Tribunal, you'll have 42 days to request the written reasons. So you need to do this if you're thinking about challenging that decision. Once you've got the written reasons, you've then got 42 days to request an appeal. So if you're going to appeal to the Tribunal, you need to do this on the basis of an error of law or mistake as to material fact. If you don't have the right evidence on the day, that isn't a reason in itself to appeal, which is why it's all the more important to make sure that you've got everything within your papers before your matter's heard. I've just put a separate note as well there, just to say that the Scottish Tribunal is slightly different. You've got 42 days to appeal from the date of the decision. It's slightly quicker process just because they tend to send the written reasons out at the same time as the decision. So it's just something to bear in mind. So just on the last slide, I've just put there my contact details. So as I said, you're more than welcome to come to us at any point for advice if you feel you need some pointers. As I said, the earlier the better, but please do feel free to get in touch and ask us any questions that you might have. Thank you.
Kim, thank you very much. Some great advice there in relation to AFCS tribunals. Kim, I can't see any questions in the chat at the moment. Am I right in saying that you and the team are open to giving help and assistance in terms of presentations and training around AFCS to organisations?
Yeah, definitely. So we've got a number of different presentations that we can give. So if you, if any individuals or teams are wanting any training, we can tailor that to specific teams. So say, for instance, we do give a lot of training to people who work in the NHS, treatment providers, letting them know about the sorts of things that our clients would be looking for in terms of evidence, or even just generally, we can give background knowledge, to the scheme, making people aware of the sorts of review provisions and different sort of things that we can look at to have clients' cases reopened and look at challenging decisions, things like that.
Thanks, Kim. That's really helpful. The scheme remains quite difficult, particularly for vulnerable clients with PTSD, so it's not an easy scheme to navigate at all. So thank you for that, Kim. Okay. Just to remind everybody, we will be making the slides available at the end of the conference. This is also being recorded as well. Feel free to ask any questions in the chat in relation to our speakers. And of course, if you have the opportunity to tweet, then it's the hashtag against the odds. So I'd like to introduce our next speaker, and that's Caroline from the charity Inquest. Military inquests are difficult. We, in terms of the Southampton military team, have had 3 or 4 inquests in the last 12 months. And military inquests are always very difficult for families, and trying to create that level playing field for them in terms of legal representation is not easy. We're helped a little bit by now Article 2 requests with public funding being made available, but it's not an easy process at all. And one of the things that is great is that there are organisations like Inquests available to offer support. So Caroline, can I hand over to you to talk through the great work that you do?
Yeah, I'm not sure if I'm dropping out or possibly me. Okay, you can hear me, that's good. Okay, yes, my name's Caroline. I'm a caseworker at the charity Inquest. A few of you may have heard of us, particularly, I suppose, in recent days with the Casey review and our recent policing report, which is just probably what we're most well known for, I guess, outside of the legal sector is our campaigning work. And I'll talk you through some of that, but with most focus on what we do in terms of casework and how we support families through the inquest process. So it's just, I'm not sure if it's clicking through. There we go. So Inquest was founded in 1981 by a group of families whose loved ones have been killed by the police. Particularly our founder is Celia Stubbs, who's a partner of Blair Peach, who was shot by the police at an anti-fascism demonstration. And we're a family-founded organisation at heart, and I think this quote really speaks to the importance of bereaved families at inquests and that idea of real change making. And I think most of Inquest's cases are in relation to policing, prison and mental health deaths. But obviously this applies just as strongly within the military, where often families are that lone voice that's saying, we don't want this to happen again. And we don't want anyone to go through the pain that we've gone through. So yeah, I think that really speaks to it. And our family listening days are a day where we either for our own internal purposes or externally, we are essentially recruited to ensure that families' voices are heard and fed into reviews and processes, rather than them being invited to a consultation where their views might be, they might be told, well, that's not how it normally happens, rather than actually organisations just listening. So this is Inquests today. This is our family reference group. So this is a group of families who sort of sit in some capacity of leadership with the organisation and feed into the work we're doing. They're families who are campaigning families and whose inquests have often happened some time ago. You've got Marcy Rigg there, sister of Sean Rigg, who died back in 2008, but has been campaigning all this time. And those are families, yeah, who just still want to be involved and want to help direct how we work. So we only work in England and Wales, really, although we have been doing some work in Scotland recently to try and encourage more of an inquest process to happen there, because there isn't an inquest process there. These bread and butter of certainly of what I do and of what inquests do is that we provide a specialist casework service to bereaved families following deaths in custody, detention and other contentious deaths and disasters. So, for example, we've worked on Grenfell, Hillsborough, and a number of other kind of concerning systemic deaths related to systemic issues. It's that casework that informs our policy, research and legal campaigning work. And we are informed, our policy work is informed by the experience of the families that we work with. And I'll talk you through some examples of that in some time. I think perhaps of interest to the lawyers in the room, some of you may be members, but we also have the Inquest Lawyers Group, and that's a pool of lawyers who are inquest specialists. And the criteria for that is that you mostly represent bereaved families. We think that's important because it is different being the family in the room where there might be other interested parties. The inquests I've attended, sometimes there's 3 or 4 other interested parties, and just even in terms of appearances, they go into a room together when conclusions are being discussed or considered. You know, what submissions will council make for the issues to be left to the jury. They go into a room together, and then the family lawyers go into a room with the family. And it can really feel like that one lone voice shouting against the state with its wealth of lawyers and ability to sometimes better control the framework. I've touched on the family reference group. We also publish press releases, briefings on issues. So Casey, for example, we've published a press release on that. We do statistical monitoring. So our stats pages are some of the most viewed pages on our website in terms of deaths in prison and in police custody. We keep those up to date, and we're often asked to provide that data to other organisations. Again, there's some of our families. So we have an integrated model, which we think is really important, that all the strands of our work intertwine and all of us feed into all aspects. So you can see we have casework, we have supporting and empowering families. We also have some family support that we offer. So twice a month we do a connection cafe, which is just a space for families to come together on Zoom and talk about their experiences of the inquest process. So we recognise that a traumatic bereavement is different to a normal bereavement, even one that might come in quite traumatic circumstances. But the idea that in a setting in which your loved one should have been safe, they were either able to take their own life or they were killed through negligence or use of force. That is really difficult for families, and sometimes, particularly with suicide, there can be stigma attached. So it's a space in which to just share how they're feeling about the process, what their feelings are towards their loved one, and the fact that they're no longer with them. And families really do enjoy that space. Once or twice a year, we also do a family forum, and again, that's bringing families together to have facilitated conversations, meet in person, and discuss the issues that they've faced and their experiences of the inquest process. And it's often those days that inform our work going forward and how we approach casework, policy, and feeding into the legal work that we do. I mean, part of my role is to work alongside the lawyers from the Inquest Lawyers Group. So it's how I choose to do that is often informed by what we learn from our family listening days and family forums. You can see there we also do some monitoring, statistics, and we identify themes and key issues. Again, I'll come on to speak about some more of that. You can see our key issues there. I won't talk through all of those, but at the forefront of everything that we do is this idea of access to justice and making sure that families are visible and at the centre of the inquest as they're supposed to be. And then anti-discrimination work sort of underpins. You can see a number of our issues. Our key areas are areas in which discrimination would naturally be at the forefront. And then our overarching strategic aim is to end deaths that are caused by unsafe systems of detention, a lack of care, the use of force, and by institutional failings. Some of the challenges we face, and I think you will also face in any inquest where the state is involved, is a lack of data. Media that can sometimes be hostile. So if there's any indication that your client or your family member did something that may mean that they, should be in some way held accountable for actions that flow from that, can be a real difficulty. Certainly in some of our cases, particularly prison ones or police use of force cases, you have to contend with what the narrative that will be put out both by those institutions, but also in the more tabloid newspapers and how they will pick up on issues that come out of the inquest and out of press releases from other interested persons. That lack of advice and information for bereaved people, I could have, if I had £1 for every time that somebody said to me, well down the line into an inquest process, I'm so glad that I found Inquest, because I didn't understand what anyone was talking about. I didn't think I needed lawyers until suddenly everyone else turned up with lawyers and I wasn't allowed to ask my questions, and I don't understand what's happening. We've also, I know it was touched on that Article 2 is now helpful in terms of funding, but there is still a real lack of specialist lawyers to assist families through the inquest process, even in those Article 2 funded cases, just because of the financial viability of doing legally aided work. There is still no funding for families in non-Article 2 cases, and recent case law, you may be familiar with the cases of Maguire and Monaghan, have curtailed Article 2 to established case law and don't seem to suggest that the courts are willing to take a more expansive view, like they perhaps did a number of years ago in Rabone. So that is concerning and a challenge that we're often facing in terms of ensuring families are represented, especially in those borderline cases where it could be that there are systemic failings, and we'd like to see the inquest as the only real mechanism of change making utilised to its full extent. Something we often come up against is state secrecy and silence. Again, I can imagine, particularly in a military context, you are, difficulties around sensitive information can also make that inquest process more challenging. Deficient investigations, that's a huge concern of ours. Obviously, there are organisations like the IOPC and the Prisons Probations Ombudsman. They conduct some measure of independent investigations, although again we're often having to threaten judicial review, which comes at a cost to the families, to ensure that those investigations are completed rigorously, and that the investigators are willing to sort of grasp the mettle from the very beginning of the process. You may be familiar with some recent cases where investigations have been reopened after an inquest into use of force, in particular by police officers, and that's just further elongating a process for families that is already incredibly difficult. In mental health related cases, there is no automatic right to an independent investigation. In fact, the framework around deaths under the care of the NHS has recently changed, so that it will now be incredibly rare to get a fully independent investigation. And we've seen that where independent investigations have been commissioned, you do often see much more critical conclusions, which then feed into the inquest process and make families' arguments for a wider scope that much easier, and the opportunity for coroners to make critical findings also much easier. Disclosure is an issue that we often run up against. Disclosure of issues that we would like to see can be difficult to obtain, if not impossible to obtain, and it's often late, comes very late in the day, or even during an inquest itself, which is obviously unacceptable, but there is no real recourse against that, given you can't make cost findings in an inquest. So there's often a lot of gamification of the system, particularly by the more well-resourced interested persons within it. And then I touched on this earlier, but the demonisation of the deceased can often be an issue, perhaps less so in military claims, but certainly it is something that can happen. Stories from the past even can be dragged out by some determined journalists. I think it was touched on at the beginning, key reforms and change making being at the forefront of the conference today. We have managed to secure independent investigations of deaths in police and prison custody. I mentioned the PPO and the IOPC. As I also said, they're not quite as rigorous as we would like them to be, but they are, I suppose, something. There is greater transparency and more information given to the families during the investigation process. That's something we've probably seen in the last 15, 20 years, is that has changed from literally nothing to at least ostensibly proper disclosure has to be provided to all interested persons. Reform of the coronial system, and of course our biggest win has been that 30-year campaign for non-means tested public funding for families at Inquests. Obviously, it's a partial win because it's only in Article 2 cases, and we would like to see it for all bereaved families where the state is represented. I believe Labour are considering that, or possibly have that on their manifesto, were they to be elected. So it's not that it's not perhaps the most unreasonable demand, and I think there is a real willingness to ensure proper participation at inquests, especially post Grenfell and post Hillsborough. The Corporate Manslaughter Act, we've actually seen recently at one of our cases, the Corporate Manslaughter Act is being used, and this now applies to deaths in custody, meaning that if there's management failures in inquests and inquiries, that can result in legal action. Shenny's law, I mentioned Shenny's law earlier, but the legislation that's come into place there, and actually has just only recently come into force, has seen prevention of use of restraint within mental health settings by the police, and that's been that's essentially 10 years in the making of campaigning, which again is a huge campaign win, and proof that change can happen, even if it's slow and laborious sometimes. Article 2 is the right to life. Again, this was touched on earlier, but it really has, if Article 2 is engaged, it really does transform the framework for investigations and the inquest process, because, without perhaps preaching to a choir, the requirement to conduct a full and effective investigation into the death is really core to those investigations, and enables families to push for more expert evidence and proper rigorous examination of experts, and also of a more expansive scope of an inquest, where how did the deceased come about their death, it is transformed into how and what circumstances, which is the answer that most families essentially want to know the answer to, Article 2 or otherwise. And ultimately that gives the bereaved families a more central role in those investigations and inquests. Article 2 also allows for much more critical findings by coroners and juries where they're sitting, which again it can only be a good thing when it comes to uncovering any failings, and hoping that the interested persons whose failings those are will feel compelled to make changes. So that leads on to then associated civil claims, which often it is where it hits in a financial way that organisations are more motivated to make those changes. Again, just some of the work that we've done around Hillsborough and around Grenfell. At Grenfell, I think one of the key things that Inquest did was put out a leaflet explaining the inquest process in, I think, over 30 languages, just to ensure that people understood the basics of what was happening, what was going to happen. And it's being equipped with understanding what's happening and what to expect that can often make a huge difference for families. Something that I always try to do when I'm speaking with families, especially where they have real trust and confidence in the state and its systems. So, for example, a family where what I was speaking with a sister and a father, and they have a history of police service and relatives who work within the NHS, and they're genuinely shocked when down the line those organisations became defensive when they asked difficult questions. So being upfront with families about what they can expect and that it may be hostile is can often make all the difference, but also tempering that with the hope that the inquest can uncover some more of the truth, if not all of the truth. Can also be really helpful in encouraging them and in managing their expectations through what is often a very long process, especially given delays in the courts. So these are just some of the ways that we focus on making change happen, which is visibility of the issues. So I think we can see with the Casey review, the failings within the Met Police are very visible, and that makes it more of a kind of a norm to want to make change happen there. And so it's our belief that using media in particular, and also our reports and ensuring that there is coverage of our reports whenever they come out, creates the onus for those with power to want to make and need to make change, because we change the narrative away from that demonisation, and we bring these issues into the light. And that's what the inquest process really offers, an opportunity to uncover what's happening behind closed doors, often, especially in custody related cases. We do research and analysis, both internally and when commissioned by other organisations, and in partnership with other organisations as well. As I mentioned, it's so key that we try to empower families, and we've chosen to do that through the inquest and inquiry process. We want to see state and corporate accountability, whether that's through the inquest or follow-on civil proceedings. And it's about evidencing truth to power. The state bodies have almost unlimited resource, it would seem, when it comes to inquests and legal proceedings. And yet it's the family who can, through their lawyers and through their stories, can often say what their experience is of what really happened and what their concerns were and whether or not those were heard. And we've seen that can lead to policy and practice change. Again, some of our priorities for change making. We have a wealth of resources for bereaved families. We have a handbook, we have fact sheets, little sort of short paragraphs about what to expect at a preliminary hearing, what to expect at an inquest, who are the IPC, what's the PPO do, when will I expect to hear from X, Y, and Z? Is it normal for an inquest to take over a year, and for me not to hear from my lawyers for months at a time? We also have a Facebook page, a closed Facebook page, and we do various family events, so untangling loss, managing media, managing yourself through the inquest process, which obviously can be lengthy. We are unashamedly, I suppose, a thorn in the side of the state, and we see our role as critical, being an independent organisation who takes no state funding from civil society, and that allows us a lot of freedom to be as critical as we feel is appropriate. We work alongside media organisations to challenge those state accounts and amplify the voices of bereaved people. We use mainstream media and smaller media organisations as well. For example, Private Eye will pick up a lot of our work just to challenge what's already out there and actually set a narrative from the beginning. That's something we also aim to do. We have 40 years of oversight, so we have a wealth of records of inquests, of prevention of future death reports, and there are colleagues of mine who've worked within the organisation for 10, 15, 30 years, so their knowledge of what's happened, what's changed, and what hasn't changed, and seeing patterns enables us to feed into other cases and other sort of systemic failings to make that change happen. So here's a little more focus on our inquest lawyers. I've touched on this before, so the early days saw no real resource for families and no sort of really legal representation. A group of lawyers who are committed to these types of cases, often taking on the cases pro bono. So we brought them together. They were working in isolation, but we wanted to pool that knowledge and that understanding, so that they could share their learnings from different cases and work collaboratively. As you can see, we've got over 400 members and we keep growing. There's some information from our archive when ILG was set up. It's really key to us that we collaborate both with lawyers and with other organisations. For example, if I have a case in a particular prison and I know that certain issues have arisen, and I know those issues have arisen in another case, I may well connect the lawyers together so that they can pull that information, that knowledge between them, in the same way that the state will obviously have all that knowledge and usually instructs the same lawyers on those cases and on those inquests. So making sure that we are as well equipped as they are, and that lawyers can learn from each other, even if they work for different firms or within different chambers. We also intervene in strategic litigation cases. So Mon, which is the case you may be familiar, changed the burden of proof for suicide and unlawful killings to a civil standard. I expect that's particularly relevant in military cases. And also the case of W80 and the IOPC. So again, that's ongoing in the Supreme Court. I think the hearing just finished in the Supreme Court. So that's around what is the is it objective or subjective belief in terms of use of police firearms. And then the Brickhouse Immigration Detention Centre, there was an expose by an undercover reporter there, resulting in an inquiry. So we'll be feeding a witness statement into that. The Inquest Lawyers Group then obviously also work with us, preparing our policy responses, for example, in the Judicial Review Bill, most recently the Bill of Rights. We've fed into those consultations and made our views known to lawmakers, and submitted statements and so on. Those are just some of the benefits of our membership. So we can assist supporting families, and we can also provide lawyers with that kind of overview of systemic issues around the cases that they're working on. So statistics, trends and patterns, we can recommend experts in issues that we've kind of used before and that others might have recommended. And we can provide that contextual information about institutions and bodies that, you know, when they're focusing on the discrete legal issues, it might not be so obvious, but is what we do on a day-to-day basis. We also do a number of trainings and seminars. Most recently, on acute behavioural disturbance and Article 2 and the changes to legal frameworks there. We have a magazine, hasn't been published in a little while, I will say, but Inquest Law, which is usually made up of case notes written by the lawyers from often the cases, and often focuses on a systemic issue. So I think our next episode will be on in relation to deaths of women, and it will discuss recent case law and the issues that are arising from that. So anyone can subscribe to Inquest Law. You don't have to be a member of ILG. I touched a bit on this, but this is what families want from the legal process, and that's truth, accountability, and change. As any of you who've represented families will know, it's not a fun process. It doesn't bring back their loved one, and even in terms of the truth that comes out of the process is often limited both by memory and by defensiveness. And families know that from quite an early stage, but all that they want is that another family doesn't go through this, because they know how difficult it is. So it's about empowering families to do that as much as they can, whether that's within the inquest process itself or also utilising media and campaigning during and after the inquest. These are the kind of areas that we usually work on, which is police, policing, prison deaths, immigration detention deaths, and deaths within mental health settings of both voluntary and involuntary patients. We also do community mental health cases of children and young people, so 24 and under, with our multi-agency failings. And unfortunately, as many of you will be aware, young people are really struggling with their mental health at the moment, and in a sort of online post-COVID generation, and so that actually makes up a good portion of our work, and are some of the most challenging cases because they don't automatically engage Article 2, and in fact rarely engage Article 2. So those inquests for the families can often be really disappointing, because they imagine that the death of a young person, and rightly, should involve some level of public outcry, but often the inquests are short form, and don't explore the circumstances leading up to their death in an effective way. And then, of course, we have Hillsborough and the Grenfell disaster. The routes to casework, usually people are Googling inquests, and I suppose that's where our name comes in quite handy, is that we're usually found through that. We do also ask investigatory bodies such as the PPO and the IOPC to refer to us. Sometimes they do, sometimes they don't. Some coroners' courts provide leaflets which have our contact details on them, so families will find us there. Different advice agencies will often cross-refer, or often other families who've had loved ones die in the same setting or institution will refer families to us. We then operate a phone advice line and an online inquiry form, and that's how people submit their applications to us. And then the last route is that people will often see us in the media and come to us via journalists. So when contacted, we provide free and independent advice on what's going to happen in the inquest and the investigations. We help families to navigate the legal process, and we explore the options of legal representation and funding. Where possible, we will refer to a solicitor, And if we're not able to find lawyers, whether that's solicitors or pro bono barristers, to act, we'll work in collaboration with other organisations who also provide free legal advice to ensure that there is some measure of representation at the inquest where at all possible. If families don't want to be represented, of course, that's fine, and we'll support them throughout the process, and indeed after the process, when our family participation arm of the organisation kind of takes over the leadership from the casework team. Once a case is referred to a lawyer, we work as part of the legal team, so we'll attend strategic meetings and hearings, and we'll try and resolve any issues that might arise between families and lawyers, just in terms of misunderstandings sometimes, or explaining what's happening, and that lawyers often have multiple cases running at the same time, and so we can be somewhere in the middle, communicating between the parties, but also literally in the room when there are lawyers' meetings and meetings perhaps with investigatory bodies. We share our knowledge around similar deaths in the same institutions, and then we can recommend experts and barristers who perhaps have specific expertise on often quite niche issues. We also help with the press, although we have a press officer, and ensuring that details of the case are shared with if the family want, with journalists who we think might pick up the case. A little case study is Woods Hole Prison. So this is where the systemic knowledge really comes into play. You can see that they had the highest number of self-inflicted deaths in prison in 2016. We ensured that all cases went to the same lawyer, and working together identified the common failures which led to review and changes in the prison, putting a stop to deaths for at least 12 months. And that's a model we can then use with other prisons, and indeed, for example, certain NHS trusts, which are areas of concern. At the minute, we are campaigning around Essex Partnership Trust, around the really high numbers of deaths in mental health settings within that trust, and we're using similar kind of model. Again, another case is Charlie Miller's, 17-year-old, where we were able to push the CQC to reinvestigate the unit where he died following two very similar deaths at the same time, and converted the investigation into an independent one. We helped the legal team instruct an expert with knowledge on mental health care for children, and also supported the application for a silk to be instructed, drawing together other case examples. One of our more recent cases is Deji Omashore. You may be familiar with this case. It happened just last year. Deji was tasered multiple times by the police during a mental health crisis. I was actually involved in this case at the time. The Met Police immediately issued a press release saying that he was carrying a screwdriver, when in fact that was later seen to be a lighter. That record wasn't corrected for a very long time, and we were able to refer the family to a legal team and have meetings with the IOPC to ensure that the narrative was corrected, and draw their attention to the web pages in which it hadn't been. And our media work there has in support of supporting the family, has really raised the profile of Deji and of the way in which he died, and hopefully garnered some interest and held the IOPC accountable in terms of their investigation, and the subsequent inquest. We now know that journalists are interested and will likely cover it, which is important to the family, that those findings, be they good or otherwise, are publicly covered. Again, another quote from a family which is that what families want is effective change so that others don't die because of the same feelings. The support of Inquests brings all this together. And the point there about having a lifelong loyalty to Inquests is something that we do see in our families who really, from the offset, want to change make, is that they don't want to stop with their own case. They want to see systemic change so that this doesn't happen anymore. Currently, our key demands are public funding for bereaved people at Inquests, where the state is represented, a national oversight mechanism, which goes to the point that inquest findings aren't binding, and even where prevention of future death report is made, it's our experience that we see the same PFDs being made at the same institutions over and over. And it is obviously within the remit of the response, the IPs who've been issued a PFD to choose not to take any further action or to say that the issues have been resolved, and yet we see at another inquest that they haven't. So we'd like to see a national oversight mechanism, which is a body with teeth to enforce those PFDs and ensure that they are being acknowledged and addressed, and that repeated failings aren't happening. And then a statutory duty of candour on public officials, which is Hillsborough law coming out of the Hillsborough inquiry. Again, ensuring transparency and openness, and that inquests are the effective investigation tool that we know they have the capacity to be. A few of our media releases there, the types of cases that we work on, and that is all from me.
Caroline, thank you very much. We've got a couple of questions, one from me, but also one from our attendees. So could you just remind us in terms of how you as an organisation are funded?
Yeah, so we rely mostly on a number of funds. So we are primarily funded by, for example, Barrow Cadbury, are one of our core funders. And that's a family fund that is kind of concerned with anti-racism. So yeah, it is primarily funds, large and small, mostly quite small funds, and then we rely on donations. A number of the law firms we work with also provide sponsorship, both in kind and monetary value on specific projects. So yeah, we're funded totally independently of government.
From your experience with cases, how are you seeing those? Have they been quite successful, or have they been quite difficult in terms of getting Article 2 funding for families?
I think in terms of Article 2, if it's an automatic case, it's fine. It's pretty straightforward. Once a coroner said it's Article 2, then the funding applications are easy enough. The challenge is where a coroner doesn't make a ruling on Article 2, and then we can run up against issues with the legal aid agency, even in those cases that we know are automatic, where they say, well, there's no ruling on Article 2, and we don't think it meets the criteria. Never mind the cases which are sort of on the cusp. And the other thing I would say is that even in the automatic Article 2 cases, we've had a few coroners recently say that self-inflicted deaths within a setting, a mental health setting, don't automatically engage Article 2, or they're not willing to rule on Article 2 to a later stage. But yeah, even the recent cases of Morahan reflect the fact that falls within the automatic category. So certainly it's an area that even the very decided issues feel up for consideration, and can be a bit more challenging in terms of getting that funding.
Well, that's really helpful. Thank you. As always, if there's a question that we can pull this together and include those in any document that we have after the conference. We're going to take a 10-minute break now. Please, if people are able to log in, if they just want to kind of mute things and mute the camera, I will return at 5 to 11, where we'll, if Craig Jones from Fighting with Pride. So thank you very much, everyone. So moving on to our next speaker, and I'm hoping that you're there, Craig. I've just been looking at your very impressive bio during the break. Like myself, a veteran, you're a former member of the Royal Navy, who has been extremely active in relation to the issues surrounding fighting with pride, which resulted in your MBE. I can see that you also gone on to have a great career in the corporate and commercial sector as well, but it's your work with fighting with pride, I think, that we want to hear today, not only in relation to the work that's been ongoing, but I understand that there's a report out in the summer, isn't there, in looking at these particular issues, and you might just want to give us a bit of an update in relation to that as well. So I'll hand over to you, Craig, and let you basically tell us about the great work you've been undertaking.
Andrew, thanks very much. And thank you for inviting me along today. It's really brilliant to be involved with Irwin Mitchell, who've been such a fantastic supporter of members of the armed forces and veterans for something like 35 years now in this space. So we're very proud to be associated with you. I'm Craig Jones. I'm the executive chair and I suppose founder of Fighting with Pride, although if I'm honest, it's not a term I use very often, but it's the reality of how we were created. We're a lived experience charity. We're very new. We've only existed for about 3 years, but in those 3 years, I'd say the journey has been a bit like being strapped to a rocket. And we've made some really pleasing progress. We're a lived experience charity, so every member of our team has in some way been affected by the ban. And in my case, it has been the guiding compass of about 35 years of my life, if I'm honest, which is kind of why I'm in this space. I've been convicted to the fact that there must be restorative justice for those most affected by the ban, and that's the journey of Fighting with Pride. And I very much hope that in the coming months it's a journey which will start to see the horizon that we've been heading for so long. I'm going to tell you a little bit about my own personal journey with the armed forces, in a way to shine a light upon some of the difficulties and challenges, because I think it's very easy to see the gay ban as being one of those things that was just the loss of a job. But of course, for those most affected, it was a great deal more than that. I'm from a working class family. I was brought up in Yorkshire, and one of my uncles was in the Royal Navy just after the Second World War, and that was just enough to make us a military family. And I was really excited by the idea of being a Royal Naval officer and doing a really exciting job. And I pictured myself going away to amazing places on warships and sitting under trees, drinking pina coladas in the Caribbean and all those manners of things. And so I set myself on a course to achieve that. And I went to the Admiralty Interview Board in Portsmouth at the age of 17, very, very naively, and had 3 days of jumping through hoops and doing paperwork and all sorts of challenging things. And at the end of my assessment, I sat in front of the Commodore of the board and he said, "Mr. Jones, we don't think you'll make a Royal Naval officer now or any time in the future." And as a increasingly tenacious Yorkshireman, it kind of absolutely galvanized me that that's what I would do. So I got closer to the Royal Navy. I went to Portsmouth University, then Polytechnic, to do my degree, and I learned everything I could about ships and aircraft and missiles and what the Royal Navy did. And I went back to the Admiralty Interview Board at the age of 20, so about 3-4 years later, and it went well. And I had the very different conversation in my second panel, in which the Commodore said, "Congratulations, you passed." And what an exciting moment for me, a moment of immense pride, but also for my family. I was going to Britannia Royal Naval College, Dartmouth. Life was going to change, but about 6 weeks before I was due to join up, I was sat in my digs at Portsmouth University, managing finally to put together the jigsaw of some of the complications that were going on in my head. And I came to the really frightening realization that I was gay. And being gay in 1989 and a member of the armed forces, or a prospective member of the armed forces, was completely toxic. The way in which LGBT plus people were being treated in the armed forces in those days was abhorrent, and ultimately resulted in a prison sentence. So it was an incredibly scary moment. Everything that I had worked towards was seemingly out of reach. But I also thought and analysed it and thought, well, I want to join the armed forces. It's going to be an exciting career, and being gay just wasn't relevant to me. I didn't know anybody that was gay, and the ban didn't make any particular sense. So I walked through the gates of Britannia Royal Naval College, up the hill, and I left my sexual orientation and anything to do with that at the main gate, never to be looked at again, seemingly. And the first 3 or 4 years in the armed forces were exactly what I hoped for. It was a real boys' own career. I flew out to the Caribbean, and I was a counter drugs operations officer in the Caribbean for about 18 months, doing boarding interception operations on the cocaine trade from South to North America. And then after that, I came back to the UK and I retrained in helicopter fast rope insertion at RAF Bryce Norton. And I went out to the Gulf after the first Gulf War and led helicopter fast rope teams doing armed insertions onto vessels coming out of the Shatt el Arab as we cleared the Shatt el Arab waterway. And by this time, I almost felt as though I joined the army, because I wore a green uniform for most of my first 5 years at variance to the Royal Navies. And that continued based on those roles, which had gone really well. I was appointed to be a patrol commander in South Down in Northern Ireland during the Troubles. And I arrived in Northern Ireland at a time which was immensely difficult. It was a moment in which the communities were at loggerheads with each other, and I learned a great deal about irrational prejudice. And really, it helped set my moral compass for the future. But towards the end of my time in Northern Ireland, there was a moment which changed my life forever, and really set me on a very, very difficult path. And I did an armed boarding off the coast of Bangor in November 1994. And as we approached, it was a fishing vessel. And as we approached the fishing vessel, I had a police sergeant with me, then Royal Ulster Constabulary, now Northern Ireland Police Force. And we hailed the vessel and nobody came to the deck. So we boarded, and as we boarded, we heard some scurrying down below, or some noise. So we both pulled our pistols, and the brave sergeant said to the young lieutenant, "You stick your head down the hatch, sir, and I'll cover you." So I did, and I was in body armour, and I got my head in the hatch and my pistol pointed forward, and I looked down, and there were two older teenage guys in each other's arms on a mattress, and they'd been startled, and they jumped up, and I told them, beckoned with my gun to get their clothes on, but I stayed wedged in the hatch so that the police sergeant couldn't see anything. I felt instantly protective, and the sergeant didn't see anything, and they came up into the well deck looking a bit tousled, but and I questioned them for about 5 minutes, as we did in Northern Ireland: name, address, date of birth, occupation, what they were doing. They said that they'd been fishing, which I thought was imaginative, and we were just about to leave. I said to the sergeant, "There's nothing here for us. We were looking for bombs and guns and contraband." And just before we left, the sergeant turned around and said, "If you're fishing, why are there no fish on this boat?" And it was one of those moments whereby you think, which way is this going to go? And very wisely for two young men, they said, "Oh, we were just pulling the pots to check if there were needed any repairs." I went back to my ship on Carlingford Lock and left the sergeant. I went back to my cabin and I closed the door and I put my head in my hands and I thought, here I am in my body armour with my pistol, with my Kevlar helmet, and I felt like a complete and utter coward. And I've just seen two young men in the most difficult and challenging of circumstances trying to be themselves, trying to live the best lives that they could. And I resolved on that day that somehow life had to change for me. Life had to be more open and as honest as I could in the very difficult circumstances of the armed forces in 1995 for people like me. And I went back to the UK, and 3 weeks later I walked into my first gay bar, which was a frightening thing in those circumstances, a frightening thing today for some young folks who are coming out, but a frightening thing for me because of the potential to be arrested and sent to prison. And I walked into the gay bar, into that particular gay bar in Exeter, sat down at the bar next to the man who has been my husband for the last 29 years. So if that's not military efficiency in dating, I really don't know what is. But from that moment, I had something to protect. I quickly developed what became my family. I had something to hide, and I would spend the next 5 years of my life looking over my shoulder for the moment when the Special Investigation Branch of the Royal Military Police might pick me up. And as you might imagine, those first few months were a wonderful experience for me. Life moved into Technicolor from the monochrome, and I went back. I was on long leave because it was an operational deployment of 2.5 years in Northern Ireland. I had long leave and went back to work in the November as the navigator of the frigate HMS Sheffield. And we were in dry dock until the January. And I was preparing in the January to sail Sheffield out of harbour. And Adam's, my husband's father, just dropped dead suddenly. And the armed forces are amazing for dealing with difficult circumstances like that, in terms of enabling compassionate leave, in terms of enabling support from family services, in terms of the military family gathering around somebody in their moment of need, as is enshrined in the Armed Forces Covenant, that we shall be there for those who stand in harm's way for us. But of course, that wasn't there for me. So what was there for me was two military police of my own rank to march me away if I told anybody. So I managed it as best I could. I sailed the frigate out of Plymouth, but was not able to do what I was there to do. And I was casevaced by helicopter to Durraford Mental Health Hospital about 8 hours after sailing. And managed to, they introduced me to a Royal Navy captain psychiatrist who was, to be frank, absolutely barking mad, far more mad than I was. And he basically said, you know, you've obviously got a bit overwrought, and sent me on long leave. And beyond that, in those days, if you had seemingly a mental health event, then it was a very, very negative career thing. So I was sent to an aircraft carrier to be navigator number 5, who sharpens pencils, I think, navigator number 4. And that was a tricky time. And it was in those years that this campaign began. So in those years, I became a very angry lieutenant, watching so many of my amazing LGBT plus colleagues marched away by the military police to really, really difficult futures. So on the day the ban was lifted, the 12th of January 2000, I came out of my closet like a rocket in response to my ship's company, which had 500 people on board, being told that it was a great pity that the ban would be lifted. In the House of Commons, the Secretary of State for Defence, then Jeff Hoon, said there will be those in the armed forces who wish that the ban remained in place, but we cannot pick and choose the laws that we implement. So it was an easement that was born in a storm. It was unwanted by senior officers in the armed forces and by the politicians. It was required by the European Court of Human Rights under an Article 8 violation of the right to a private life, and that set the course for the next 4 years from 2000 about how the military would deal with the whole issue. It was a policy that dare not speak its name, and those years were incredibly difficult. And I did lots and lots of petitioning for change. I was very outspoken. I leaked stuff to the press. I think I'm allowed to say that now. It's water under the bridge. And they did give me a medal eventually, thankfully. And I sparred with admirals and generals in the papers, and I wrote to politicians. And I remember on the Thursday before Trooping the Colour in 2004, I got a letter from an admiral expressing his really severe displeasure with me, which is a technical term for us. It's like a written warning, because I'd been very outspoken about this issue. And in any campaign, and we're talking here about against the odds, you never know where your luck's going to come. And on that Saturday, I went to Trooping the Colour with Adam. He was in morning dress. I was in number 5s with my buttons brightly polished for Her Majesty. And I sat down next to a lovely older gentleman in morning dress. And he said to me, "Hello, Commander," which was kind because I was a lieutenant commander. He said, "How's your week been?" And I was completely fired up. And I said, "Sir, it's been bloody awful." And he said, "Well, I've seen this pageantry probably 30 times. So you tell me about your week. It sounds much more exciting." And I talked to him about the loss of the diversity business case in our armed forces, about the fact that we had these wonderful and loyal and courageous men and women who had served and met not just the challenges of being in the armed forces, but all of these additional challenges that have been placed in their pathway. And the fact that we were still losing so many people because of this septic environment, when in fact we should be recruiting these amazing people and helping them have careers that thrive so that we could improve operational effectiveness at the front line. And he got it. And my luck was that it was Lord Armstrong of Ilminster, probably the most important civil servant of the second half of the 20th century, cabinet secretary to Margaret Thatcher. And 3 weeks later, we accepted an invite to go to Leeds Castle for a private weekend. All I knew was that I was meeting Lord Armstrong, but when we got there, we met with Admiral Lord West of Spithead and Lady West, who was then First Sea Lord. And over the course of that weekend, I explained to First Sea Lord, without the encumbrance of captains and commodores, rear admirals, vice admirals, and various other folks interfering with my business case, and I explained to him the opportunity of creating this warm welcome, and he got it, which was really welcomed, and we changed the armed forces, and eventually the Chief of the Air Staff and the Chief of the General Staff accepted that we could be a fantastic employer and that this wasn't truly a threat. And today I would say that in Fighting with Pride, we are immensely proud of what our armed forces have achieved. LGBT plus personnel are welcome at the front line of operations all over the world. They do a brilliant job and they're supported at every level of command. In no workplace does everything go perfectly. So there will always be cases whereby something's not quite right. But what we hope the armed forces have created, and what we believe they've created, is a circumstance whereby somebody can put their hand up if something's not right and say, "Help, this isn't for me." But the reason Fighting with Pride exists is because in the 22 years since the ban was lifted, nothing has been done to support those most affected by the bans and the way that it was implemented. And I want to talk to you now about the times of the ban and its legacy, just so we have a clear understanding of what it meant. So when I met my husband in 1995, if anybody had found out, I would have been arrested and I would have been interrogated. That is, and I mean interrogated, that is the wartime role of the Royal Military Police. And those interrogations commonly went on for 3 or 4 days. I haven't yet met anybody who had legal counsel with them during one of those interrogations. And as somebody who served during that period, I know that that is a complete variance to what people experienced if they were accused of an assault or of theft or of some other style of offence. But for LGBT plus offences, there was never legal counsel there, which is an absolute disgrace. At some point during those investigations, those who had been caught in the wrong moment were taken to military hospitals, and they were subjected to inspections which have no place alongside the Hippocratic Oath and are a national disgrace. And the impact of those medical inspections endures today in the minds of those that they were conducted on as an abhorrent violation, and today would be a criminal act, I'm sure. At the end of those investigations, people were charged with the criminal offence of homosexuality. You didn't actually need to do anything, you just needed to be. So if you admitted to homosexuality, you could be court-martialed. And at court-martial, the burden of proof was fairly uncomplicated. There wasn't really a need for any. And I've not heard of any case going to court-martial that did not result in dismissal at the very least. So the conviction being agreed. For those who were ratings, the tariff was 6 months in a military detention quarters, sometimes with 2 or 3 weeks of remission. But for officers like me, you can't go to detention quarters, so I would have served 6 months in a civilian prison. Beyond that, people were literally marched to the main gate and dismissed without any regard for duty of care. And bear in mind that people lost so much on those days, and I'll talk in a few moments about the impact of being dismissed. Some were luckier, and were forced to resign by the SIB or by their commands during the investigation phases. We suspect that that was probably in many cases, to protect from future litigation. And a few were administratively discharged, particularly where there was an incumbent mental health issue caused by the ban. So really, really awful impact. And of course, their record cards were annotated in red pen with dismissed in disgrace, or dismissed services no longer required, or temperamentally unsuitable, which all meant the same thing. They meant that they were LGBT plus, and that was identifying them to anybody who knew anything about the armed forces system. And of course, very sadly, many received criminal records. And what's the impact of those criminal records? Well, let me give you one example. And that's a lovely veteran called Chris, who lives in Manchester. And in 2017, he received a knock on the door unexpected, and Greater Manchester Police were on the doorstep. And under threat of arrest, they required him to give swabs for the National Criminal Intelligence Database. 2017. He was dismissed from the army in 1983 because of an affair with another 25-year-old soldier. So his offence was homosexuality in the armed forces, and somebody thought that it was okay to check out in 2017 whether he'd done anything else. Really, really beggars belief. Next slide, please. Thank you. I'm just going to play you a short video that just gives a little bit of insight into what our organisation is about, and it comes from the voices of the veterans themselves. Hopefully with some sound. Are we able to switch the sound on? Okay, no worries. Perhaps we should come back to the. That's fine. No worries. Just move on to the next slide. Thank you. Brilliant. Thank you. So we might be able to come back to the video, but let me talk a little bit about the consequences, perhaps my voice rather than the veterans concerned. An awful lot of us come from military families. Being outed as gay in the 1970s, 80s or 90s was not great in an armed forces family. So an awful lot of our folks, as they walked to the main gate, literally had no home to go to. They lost their military home, they lost their family home. So the incidence of homelessness in this community is very, very strong. You became isolated from the military community itself because you couldn't talk to people who were dismissed from your unit. If you did so after they left, then the finger of suspicion was pointed at you, and it would only be a short time before the SIB arrived at your door. So immediately there were crises of housing and income and employment. In absolute desperation, many turned to the doors of the military charities. But most of the military charities in the 1970s and 1980s certainly had a policy of not supporting people who were dismissed in disgrace from HM forces. So really, very sad. And of course, they lost the ability to accrue pensions. And for those who went via a military prison, their pensions were reduced. So very, very sad. And of course, lots of them couldn't continue in their chosen careers. If there were people from the medical branch, for example, or people who were teaching, then those careers were not available because of the convictions. Their service identity was taken away. At court-martial, they commonly had their medals ceremonially ripped from their uniforms and destroyed. That loss of respect and dignity and pride and trust had a catastrophic impact that endures today on people's mental health and well-being, and also their physical health. So within this community, lots and lots of our members have enduring issues to do with their health and well-being. Next slide, please. So we began our journey on the 20th anniversary of the lifting of the ban. I reached back to 9 individuals who I had served with over the years, or who I knew through the campaign, to bring together an anthology book called Fighting with Pride. And we started off wanting to really record the history of the ban because it was being lost. It's a history which perhaps some authorities might prefer not to remember, but very, very sad. But by the time we'd finished pulling the book together, we were angry about the fact that the ban lives on in so many members of our community. I was very fortunate to choose the day that I left the armed forces in 2008, but so many of my colleagues did not have that opportunity. So on the 20th anniversary in the Palace of Westminster, we launched Fighting with Pride as a charity with the aim of enabling restorative justice for those most affected. And we have had fantastic support as we've opened doors. I kind of thought that it would be back to the days of 2002 or 2003 of effectively chaining myself to the railings in Whitehall. But actually, as we've knocked on the door of so many senior figures in the veterans arena and also in Westminster and the devolved parliaments, they've recognised the fact that this is a matter of the Armed Forces Covenant for the veterans. It's a mental health matter. It's an LGBT plus matter. It's to do with the values of the United Kingdom and enabling restorative justice for this group of amazing men and women who served in our armed forces is a matter of honour in my view for the United Kingdom. Our patron is, next slide please, is Lieutenant General Sir Andrew Gregory, who is the Chief Executive of SAFA. He's absolutely amazing. He volunteered to help us as much as he possibly could in the first 60 seconds of our first phone call. So really pleasing to see. And he's guided us every step of the way. We've won cross-party support during one of the periods in which Johnny Mercer was not a government minister. He volunteered to be our ambassador, and when he became a government minister again, we didn't let him off the hook. So he's still an ambassador of Fighting with Pride and a very early supporter, and we're very proud to have him in our team. And we have Dan Carden from Labour, who has represented us many times on the floor in the House of Commons, and Carol Monaghan from the SNP, all absolutely fantastic people who are supporting us every step of the way. Let me talk now a little bit about the 4 things that Fighting with Pride does. I think, next slide please, I think perhaps the most important one is our policy work, because we recognised that unless we can unlock reparations and reconciliation for this community, then we're not going to solve the many other problems that these veterans face in their lives. So we went to Westminster and we appeared before the Select Committee on the Armed Forces Bill, myself and Caroline Page, in the summer of 2021. And in the course of that, we petitioned for the fact that it was a matter of duty that we went back and did anything that we could to support these incredible people. And it was our belief that that needed to be done through the purpose of an independent review. And the independent review was announced in January this year, much to our absolute delight. We're engaged in capacity building across the veterans sector to help all of these wonderful veterans organisations find their rainbow, because with the greatest respect to our lovely colleagues, charities in the veterans sector, some of them have a bit of a journey ahead of them in terms of understanding this community and how they can be helped. But the willingness is there, and that's what's important. We provide direct support and community building. 35 of our veterans are in Ypres today at the Menin Gate, paying respects as all other veterans pay respects. But the difference is that those 35 are doing that for the first time, as they marched in the National Service of Remembrance this year for the first time, and as they are being welcomed for the first time by their fellow charities. And we have a research team at Northumbria University, which is doing some fantastic work to make sure that we chronicle the ban, that we understand the ban, we understand its impacts, and so that we can create a better future. Our pathway for the future has been enshrined in the Veterans Strategy Action Plan, and we are broadly supported by the Office for Veterans Affairs, which we've been very grateful for. Next slide, please. And skip to the next one again. We've worked with the Office for Veterans Affairs and the independent review to inform the review and to make sure that the veterans know that it's going on. This community is uniquely disconnected. You will not find them in the Royal British Legion or in SAFA or in many of the other military charities because they have not been welcome. So we've had to reach across the whole of the UK into LGBT communities to make sure that they have had that really important moment on the beginning of their restorative journey to give evidence. And we've supported Lord Etherton every step of the way with his findings. Next slide, please. We've had fantastic support. The NHS was a very early supporter. Our founding supporters are NHS England, Stonewall, the British Legion and SAFA. And we've had broad support from NHS organisations, governmental organisations and fellow charities across the whole of the UK. To enable capacity building, we've created a standard, the Pride in Veterans Standard, which is a simple toolkit to allow all these fantastic organisations to find their rainbow. And we'll welcome our 50th member of the Pride in Veterans Standard in the very near future. In fact, we're looking for a 50th member, Erwin Mitchell. It could be you. But if anybody else on this call is from an organisation that would like to join, you're very welcome. It's free, and essentially it's just a simple pledge to the fact that you will be brilliant places for LGBT veterans to be. Next slide, please. Okay, so the Pride and Veteran Standard will create this warm welcome. It means that when you look on a veterans organisation's website, you'll see something which relates to LGBT plus people who may at the beginning feel as though your organisations, particularly if they're military organisations, are not a place that they will feel welcome. It's to stop that predilection that's in their minds. And if we look at the next slide, you'll see a picture that's on a reel on the front page of Veterans NHS Wales's website. There are 5 depictions of families, and that's one of them. And I guarantee LGBT plus people looking at that website will see that that's a place for them to be. We're engaging in community building, next slide, across the whole of the UK. That's bringing the veterans together, helping them to enjoy great times and create new memories. And I'll show you some pictures in a few moments of the amazing veterans that we've reached. But also to create the opportunity for them to mix with people who have had similar journeys in life and who they can share some of the difficulties of the past. And next slide, please. We have 7 veterans community workers across the whole of the UK. They're funded by the Armed Forces Government Fund Trust until January next year. And they have had an incredible impact in terms of being able to build this community, because remember, this community was cast asunder. They were deliberately dispersed, and we've had to reach far and wide to make sure that we can get them back together. So if we look at the next slide, you'll see some of the activities that we've engaged in. The first one is mostly of some of our activity breaks in Wales. We did some I don't know if it's pictured on there, we did some co-steering on there, which is jumping off cliffs into the sea. And we took a 80-year-old Royal Marine with us, which caused me to reach for our insurance policy just to check the detail. I know you'd be proud of me, Owen Mitchell, for reading it. And but they're having amazing times. They're mixing with people, some of whom they remember from back in the day, and some of whom have simply been through similar experiences, and they have that opportunity to talk to people who truly understand how difficult the ban has been. And actually the next picture is of some of the waterborne activities in Wales, which have been truly amazing. The Welsh government have been incredibly supportive of us. And my final picture of people is of that moment of inclusion, because we are not here to create an enclave. We're here to reintroduce people to the Armed Forces family. And there is no more profound example of that than when our community marched for the first time last year in the National Service Remembrance, standing shoulder to shoulder with all other veterans organisations as we pay our respects. And it was a profoundly moving moment. And similarly, after the Snowdonia all-female trip, 10 members of our community walked back through the door of the Women's Royal Army Corps Association ball six months later, and were clapped and cheered as individuals being welcomed back into that community. And for us, that's a profoundly moving moment. And you can, even today, you can probably still hear it in my voice. It's just amazing to see that part of that important journey coming to an end. We know that we need to be evidence-based in everything that we do. That's why we've got an amazing research team at Northumbria University, and they are doing some brilliant research for us. And I'm at grave danger of running over time, so I'm going to be careful with my lovely hosts, and I'll close there. But thank you for the opportunity to tell you a little bit about Fighting with Pride and the journey that we've had over the last 3 years. It's been a really exciting journey. Very rarely in your life do you get the opportunity to pick up a lost cause and achieve something that can change so many lives.
Great, thank you very much. A very personal and an emotional presentation and account there, which so I'm sure everybody appreciates what you've said today. I remember in 1999 when I joined the Army Legal Services, and I was looking at the policy that you've talked about, and I was almost disbelief that I was joining what I thought was an amazing organisation, and I have so many happy memories. Looking at this policy and thinking, can't be right. There must be some typos that say work that you and the organisation have done over the past few years has been absolutely amazing, and hopefully now we'll see things in a more positive way. In relation to the co-steering, I did it with my little boy for the first time in the summer. I don't know how good a height you are. I'm not very good at all. But when you're a 9-year-old is leaping on a cliff, you feel I have to follow. I was just thinking about more health and safety. This is okay.
Yeah, it's definitely something to do in your 20s or 30s, I think. But there we are.
Absolutely. There aren't any questions, but as always, if there are any follow-up matters that we can, put to you, then we can include that in the document. I know that going forward, Owen, Mitchell, and Fife Pride are going to be working together. I hope on a number of things over the next few months. So I'm really looking forward to working with you. But thank you very much for the presentation today.
Thank you. Really nice to see you.
So moving on to speakers, we Dr. Charlotte Herriot and Professor Matt Bossy. They themselves have been involved in some quite interesting and hard-hitting research over the past few months, if not a couple of years, in relation to sexual violence, specifically looking within the military community. So I don't know whether it be you speaking, Harry, or whether you might do a bit of a double active in relation to this. Both mute at the moment.
Am I unmuted? Can you hear me?
There you go. Yeah, absolutely. Okay.
Okay, perfect.
So
Can
I hand it to you and I'll you to take the presentation for?
Yeah, sure. Can you guys see that?
Yeah, I can see it, Lottie.
Okay, perfect. I will pass it over to Matt to introduce.
Okay, wonderful. Thanks. Are you in charge of moving the slides on, Lottie?
Yes.
Or
Yeah,
brilliant. Thank you. Well, good morning, everybody, and thank you so much for giving Lottie and I the opportunity to talk a little bit about our research. I'm merely the warm-up act. I'm going to be here for maybe just a couple of minutes, just to give you a flavour of the broad work that we do within the institute that I'm the director of, and then Lottie will talk in more detail about some of the research that we're doing. So, kind of next slide, please, Lottie. Okay, so it's just very briefly, this is a sort of a very brief overview of some of the work that we do. In fact, just having a quick look at it, it is a little bit out of date, sorry. So as a team, there's around about 20 of us working within the Veterans and Families Institute, and also working in a research centre that's specifically looking at issues relating to women in the military. When I talk about women in the military, I don't just mean service personnel. I'm talking about veterans, spouses, and others working in that field as well, also including civil servants, contractors, etc. So we do, as you can see from this slide, a lot of work. We've brought in round about nearly sort of £5.5 million worth of research income now, and nearly 200 academic outputs. So we are really ramping up. But we have a number of PhD students working on these issues, as well as a team of academics. Also importantly, the way that universities are measured, we have to go through this awful process about every 7 years called the Research Excellence Framework, which as researchers we contribute to. And I'm very proud that within my team, we were able to demonstrate world-leading research impact. So what that means is that we can take our academic work and actually demonstrate that it has makes a real difference on the shop floor. Next slide, please, Lottie. Okay, wonderful. So this is just a quick overview of the work that we do, and what we're going to focus on is work that sort of happens within the Centre for Military Women's Research, and Lottie will talk about that. But it's just so that you can see from this this Venn diagram that our work is broadly across 5 different sectors. So there's a lot of work that we do with military families. A lot of work that we do that uses narrative, so we're mainly social scientists and qualitative researchers, so we do a lot of interviewing of our research participants and understanding their stories and their narratives, which helps us to then to understand better the communities that we work with. We do work on labour migration. Labour migration, this is both people leaving the military and transitioning back into civilian life and trying to find suitable employment. But also we do a lot of work in the field of non-UK individuals that join the British military. So some really interesting work we've been commissioned to do around that. And we also do a lot of work around equalities, diversity and inclusion, and which is led by my colleague Lauren, who's currently on maternity leave. So unfortunately she can't be here to talk about this work. Lottie will talk about work that fits within this domain. It's also worthwhile saying as well that in terms of the work we do around sexual violence, I co-chair the NATO research group on sexual violence, and we're due to report within the next 6 months or so. And that's a really interesting work that we do there. And if you're interested, we're holding a conference in December, which I think Lottie will maybe touch upon in her presentation as well. And of course, you're all welcome to come to the conference, and colleagues from NATO will be there talking more broadly around that work, as well as lots of other interesting things around sexual violence in the military. Next slide, please, Lottie. And finally, this is just to give you a sort of a few sort of ideas of some of the sort of the key projects that we're doing within the area of women in the military, and some of the funders that we have. So the funders are on the left of the screen. So these include everybody from the National Institute for Health Research through to government departments like the Cabinet Office, Arts and Humanities Research Council, and also Forces charities as well, like Blesma, the limbless charity. As you can see from this list, there are also some sort of quite interesting pieces of work that are around military sexual violence, again, that Lottie will talk about. I think, is that the last of my slides, Lottie?
Just this one.
Okay. Right, so this is just so that you can see who we are. So as you can see, this is the sort of the makeup of the staff group. We have quite a our staff group are made up of a whole mixture of early career researchers, so people that have just sort of completed their PhDs, to people that are currently undertaking doctoral studies, all the way through to professors like me who've been in the game for a little bit. But we also have a lot of visiting appointments as well, and there's a number of visiting appointments here. In fact, I need to change that a little bit, because Louise, who was working for the King Edward, the 7th Hospital, is now actually working within our team. So she's left the King Edwards to come and join us. So great. Well, that's a sort of a general sort of very, very, very quick whistle-stop overview of the stuff that we do. And I want to hand over to Lottie, if I can now, who will talk with aplomb about some of the research that we're doing. And then I'll be hanging around for questions. Thank you.
Perfect. Thanks, Matt. So yeah, as Matt said, some of the research that we're doing, which is what I'm going to be talking about today, is around sexual offences in the military, and particularly we're concerned with women's experiences of sexual offences and servicemen's experiences as well. So we're currently recruiting a PhD student to look into servicemen's experiences, as that's something that we've not looked into in detail yet. And also particularly looking at the military justice response, so looking at the service justice system and current sort of policies and procedures that have been put in place, but also some of the inadequacies that we're observing within that system. So, as I'm sure a lot of you will be aware, debate and discussion around sexual violence in recent years has kind of reached unprecedented levels, and we're seeing lots and lots of mainstream public and media discussion around sexual offences, and particularly conversations looking at the adequacy or perhaps the inadequacy of criminal justice responses. So there's lots of kind of popular media discourse around that, and you might have seen a lot of that on the news. in terms of the military, we've seen very similar discourses coming out, and lots of concern around sort of the prevalence and extent of sexual offences that have been perpetrated within the military, and also looking at the current response and whether that is adequate. So on here, we've just got a few sort of media headlines that you may or may not have seen around some of the issues that are coming out in terms of the military's experiences and responses to sexual offences, and that's kind of where our research is coming from. So whilst there's been a lot of research and a growing body of research in the US and Canada, especially looking at sexual offences in the military, there's been a real paucity of research in the UK context looking at service personnel's experiences here and our service justice system. So that's where our research is coming in, and we're working on sort of a series of projects at the moment. So we're still in the early stages of the research that we're doing, but it's a massively growing area, and we're hoping to carry on in this trajectory as much as possible. So just a little bit of background around the prevalence rates of sexual offences in the military. It's very difficult to get sort of accurate data. There's been some questionnaires and surveys done in service by the Army, the RAF, the Navy, but they tend to not be sort of tri-service data, and the phrasing of the questions and the questions that are being asked vary substantially, so it's quite difficult to compare that. But what we are seeing is that up to 99% of service personnel have experienced some form of sort of generalised sexual behaviours, whether personally or directed at another, in the past 12 months. So that's mainly sort of falls into the category of sexual harassment right the way through to sort of serious sexual offences. But it really shows the extent and the culture that's sort of around sexual offences in the military. And we've got some self-report sort of survey data that's showing various levels of sexual assault within the previous 12 months. Again, it's difficult to sort of compare that to civilian systems and between each service, because the nature of the questioning does sort of vary significantly. But what we are definitely seeing is that women and service women are massively overrepresented as victims of sexual offences within the military. So women currently make up approximately 11% of the UK Armed Forces, but are 76% of sexual offences complainants within the service justice system. So we're seeing huge disproportionality in terms of service women's experiences. And recent data has shown that service women are 10 times more likely to experience sexual harassment in the previous 12 months, and more than twice as likely to experience sexual assault, serious sexual assault or rape. So far, the research that we're doing is predominantly focused on service women because of this disproportionate nature. But as I say, we are sort of expanding on that and looking at service men's experiences, because we think there's a real difference in experience there, and we want to sort of look into what's going on. So some of the research that we're doing at the moment, we've recently completed interviews with female veterans around their experiences of sexual offences in the military, and whether they sort of made that decision to report into the service justice system. If they didn't, what were their sort of reasoning behind that? And if they did, what was their experience? And we were hoping to sort of be able to give you some of that, some of our initial findings from that in today's presentation, but we're not at the stage of analysis yet. So as Matt said, we've got the conference coming up in December, and we hope to have a sort of really holistic view and comprehensive oversight of what's going on in that system at the moment. But ultimately, sort of when we're looking at statistics, as I said, it's difficult to get an extent, and lots of evidence is suggesting that all of these statistics are likely an underestimation of the current prevalence that we're seeing in the armed forces. So it's really important to get that data and to scrutinise kind of what's going on in the system. So the first question for us to tackle is kind of why are we seeing such high rates of prevalence of sexual offences, and particularly sexual harassment within the UK military? And that's where we need to interrogate ideas around sort of military culture and the potential sort of acceptability of inappropriate behaviours in service. So I will say from the outset that the MAD are taking this seriously, and we're seeing various policies and processes that are being put into place at the moment to try and tackle attitudes and behaviours within service. So we've had things like a zero tolerance approach to sexual offences within service, where if someone is convicted at court-martial, then they will instantly be dismissed from service. The MOD are running active bystander training to try and challenge these behaviours when they're seen. And there's sort of a variety of attempts to try and challenge the culture that we're seeing. But ultimately, it's still important to interrogate what's going on and how that underlying culture might be permissive of sexual violence perpetration. So the first sort of big thing that we're thinking of is the hypermasculine military culture that we see. So the military continues to be significantly male dominated, and there's also a tendency to privilege those stereotypically masculine characteristics, so things like strength and courage, over those characteristics portrayed as feminine, so emotionality and caring. And there's some justification for this in terms of, you know, operational readiness and making sure that people are ready to fight. But at the same time, this can create a particular challenge in terms of combating sexual violence and the extent of sexual violence that we're seeing. So we need to interrogate kind of that underlying hypermasculine culture and how it can feed into the perpetration of sexual violence that we see. And what we're seeing is kind of subtle discrimination and also structural discrimination around that hypermasculine sort of white male characteristic is being privileged over characteristics of sort of femininity. And again, this can feed into the amount of sexual violence that we're seeing within the military. So drawing on the US literature, as I said, there's a lack of literature in the UK context, but we see that places where there's higher amounts of sort of those hypermasculine characteristics, we tend to see increased sexual aggression and an increased prevalence of sexual harassment and sexual assault. So just drawing on sort of some of the aspects of military culture that are potentially sort of permissive of sexual violence, we've got sort of strong value placed on obedience and sort of listening to the chain of command. Again, there's justification around operational readiness, but it's also feeding into the sort of sexualized culture that we see. The protection of the military as an institution, so people not feeling that they can speak out, and a system that is protective of perpetrators within their ranks. We also have an acceptability of sort of sexualized banter on the basis that it's necessary to build camaraderie, and that heavy drinking culture, and all of these have come together to act as risk factors and create in a context where potentially we're seeing more sexual violence perpetration occurring. So we need to think about sort of how does this culture underpin sexual violence perpetration, and also does it impact on the adequacy and the quality of the response that's offered. So this is kind of where the majority of our research is focused in terms of actually what are the challenges in responding to sexual offences within the military generally, and particularly within the service justice system. So I'm so sure you've all seen headlines around the challenges that we're seeing in terms of responding to sexual offences in the civilian criminal justice system. And a lot of these challenges are somewhat mirrored within the service justice system. But then we've also got sort of additional and compounded barriers associated with the unique characteristics of that military context. And that's where the military culture plays a part, and also the sort of setup of the service justice system as well. So I will say, against the backdrop that we're seeing at the moment, there's been a big discussion around whether the service justice system is effective in dealing with sexual offences cases. And there was a review by Lyons in 2018 that recommended that murder, rape and manslaughter should be dealt with in civilian systems and be taken out of the service justice system. There's been a lot of back and forth around whether that recommendation should be implemented, but ultimately it's been decided that that's not going to go ahead. So the jurisdiction for murder, rape and manslaughter will remain in the service justice system. And so I don't want to dwell too much on sort of the that civilian route, although it does exist. So there is an option for victims to report to either the civilian justice system or the service justice system. There is some question around how well that's publicised to victims, but ultimately sort of the focus of this presentation is going to be on the service justice system and the service justice system's response. So what I'm going to do for the remainder of the presentation is just look at individual aspects of the service justice system and think about what are the challenges that we're seeing within that aspect. So this is theoretical at the moment, and we are conducting sort of primary research to try and build on what we're finding here. But at the moment we're relying on existing research and sort of drawing that together to look at how adequate the service justice system is. So in terms of sort of formal reporting, this remains very low within the service justice system. So we're estimating somewhere around 5%. So of all victims of sexual offences, only 5% of those will report into the service justice system. That compares to about 16% in the civilian justice system. So we're seeing this as a huge rate of attrition in both systems, but ultimately the service justice system is particularly problematic in this sense. And lots of the barriers to reporting that we see are very similar to those that are seen in civilian context. So things like fear of not being believed, fear that justice will not be achieved, and those kind of generic issues that we see in both systems. But then in terms of the service justice system, we're seeing compounded barriers that are faced by service personnel. So things like not wanting to harm their career, not wanting to break that so-called warrior code. And we see that's particularly problematic with female service personnel, because there's already an attitude sort of underlying as whether female personnel should be in the military, should be on the front line, and that can have a real impact on women, service women, especially the women we've spoken to, not wanting to report for fear that it adds to the sort of argument that they're not fit to be there. There's also an idea that they don't want to lower morale of the unit. A lot of the time we see that sexual offences occurring within that unit, so it's very sort of close to home and it can be very difficult. Alongside that, we see issues that if someone does report, you've got the kind of proximity of victims and perpetrators that again make it very difficult to continue with their military careers. And we see lots of people losing their military career as a result of experiencing sexual offences and or of making a report. And alongside that, we've got issues around sort of knowing who to report to. So like I say, the MOD are acting on this at the moment, and there's clearer guidance that appears to be coming out around who takes jurisdiction for these offences. But ultimately, there is a lack of understanding amongst service personnel that's sort of reporting. They don't know who to contact and who to report to. So we'll go on to the next slide. Then we've got sort of the issue around investigations. So investigations currently carried out by service police. I will sort of at the bottom of the slide there, you can see that there's been a recent launch of the Defence Serious Crime Unit, and that's a very welcome sort of launch in that it's putting taking the investigation of this sort of into a environment where these people are trained and have sort of specialist training around how to support and how to investigate these offences. But this has been very recently launched, so with sort of lots of the data that we've got is around areas of vulnerability within the service police and concerns around the appropriateness of and expertise of service police in sort of dealing with these crimes. So service police act as more of sort of a CPD role rather than a trained role, so they're moving every 2 to 3 years, which makes it difficult to get that expertise and to build up that training around supporting sexual offences victims who we know are very vulnerable victims. There is the opportunity for service police to use civilian police resources, and that's very much welcomed because there's a much smaller number of sexual violence complainants coming forward within the service system. So having that opportunity to sort of draw on the civilian police resources is extremely useful. But again, because of the lack of research in this area, we don't really know what extent that's used and how much it's sort of implemented. So whilst we're seeing this Defence Serious Crime Unit being launched, again, we need some evaluation and some independent sort of research looking into how this is operating, whether there are still sort of holes within the system, if you like. Particularly, you know, if we're drawing on evidence from the civilian system, we know that there's still huge issues in terms of investigating sexual offences and particularly rape. So we want to see how that's being done within this serious crime unit and whether the service investigations are sort of adequate and up to scratch. Then we come on to prosecutions, and what I will say is prosecutions within the service system are actually much, much higher than those that we're seeing in the civilian system at the moment. So within the civilian system, the prosecution rate is really, really low. It's dipped as low as 1%, and there's been lots and lots of outcry and campaigning around improving current prosecution rates within the Crown Prosecution Service. In the service justice system, we are actually seeing much higher prosecution rates, which is very much welcomed and means that cases are getting to court-martial. So we're seeing for sexual offences generally, we've got about 48% of sexual offences cases are prosecuted, and that drops to about 44% when considering rape cases. So whilst it's not really high, it's still much higher than we're seeing in the civilian system, and is potentially something where the service justice system is positive compared to that civilian system. The service prosecutions are dealt with by the Service Prosecuting Authority, and they act in accordance with the Code for Armed Prosecutors, so there's an equity with the civilian system there. The bit that I put at the bottom is something that, again, there needs to be more research into. There needs to be potentially more transparency and figures looking into this, but there is some evidence to suggest that cases are being downgraded within the prosecution stage, within the service justice system. So potentially, if cases are being reported as a sexual assault, they might be being reclassified under the guise of different offences, so things like ill treatment of subordinates, disgraceful conduct, and that can carry lesser sentences and can be sort of sent back to be dealt with within the chain of command rather than being dealt with in the service justice system. So there's some evidence that that's being done, but we don't know to what extent, and we need that kind of transparency of those figures in order to ascertain the extent that this is an issue and how much this is impacting on the outcomes of sexual offences cases within the service justice system. So it's something that we kind of need to collect more data on. And then going through to court-martial, we're seeing that the conviction rate at court-martial is particularly low for rape cases. These measurements are measured over a 6-year period, so 2015 to 2020, because there's a lack of numbers, essentially, to make sort of broad statistical claims doing a year-on-year average. What I will say is 2017, I think, was the lowest convictions for rape, and that was just at 4%. So this is of cases reaching trial, and this is representing a lower conviction rate than we're seeing in the civilian system. So in the civilian system at the moment, I think it's somewhere around 70% of cases that reach trial. Obviously, we know that lots of cases in the civilian system aren't being prosecuted, so there's that disparity there. But ultimately, we are seeing a low conviction rate at court-martial, particularly for rape cases, and that's, again, something that we need to interrogate. So at the moment, we don't really have much evidence regarding the kind of evidence that's presented at court-martial cases and the narratives that are presented during court-martial trials. So this is something that we're hoping to go on to research in the future, and we're currently putting together some bids to actually look into this. But it's something that we want to interrogate to know kind of what's going on at the court-martial stage and whether we can this conviction rate can be improved based on that. In terms of the sort of time and delays, court-martial is positive compared to the civilian system. So the average time for initial hearing to completion of the case in court-martial is around 119 days. Looking at figures in the civilian system, that's around sort of 480 days for sexual offences cases generally, and up to 672 days for rape cases. So we're definitely seeing a real positive within the service justice system in that sense. But again, it's interrogating what's going on in the court-martial and opening that up to independent scrutiny to try and get an idea of how we might improve that conviction rate. The court-martial operates as a board, which is essentially their version of a jury, but it's much smaller in terms of the numbers that we see. So the board will operate with 3 to 6 lay members, depending on what offence is committed, compared to the 12 that we see in the civilian jury. There's sort of arguments for and against that I won't go into for this presentation, but it's something to consider. And of those people sitting on the board, they're typically comprised of military personnel within the senior ranks. So the Armed Forces Act of 2021 has expanded the amount of people that can sit on a court-martial board, but we're still seeing sort of more senior personnel sitting on those boards, which means inherently we're more likely to see male personnel. So that's been a real critique of the court-martial response, with the suggestion that we're not seeing that female representation. So recently they've just passed a law that said all court-martial boards should have at least 1 female member sitting on them, which we definitely do welcome. But again, it's trying to interrogate actually how much is this going to have an effect, and what's going on with those court-martial boards. So obviously both in the civilian and the service justice system. We as a safeguard, we don't know how the board or the jury are deliberating and what they're discussing, but we do have sort of multiple jury research within the civilian system, and potentially that's something that we could mirror within the service justice system to try and get an idea of how these cases are being decided, as obviously that's really important for the conviction rate. So that's kind of a whistle-stop tour of some of the issues and challenges that we're seeing within the service justice response to sexual offences, and something that we need to consider sort of where we place our efforts and how we interrogate to try and improve those responses for victim survivors and also improve the sort of justice outcomes that we're seeing. So I've not necessarily got sort of robust conclusions, and I think it's more questions than conclusions at the moment. But ultimately, we know that we need to challenge these institutional cultures. And like I say, the MOD are starting to do this, and there is a trajectory that's increasing sort of effort in this area, but I think this really needs to be expedited to make sure that we are seeing much less prevalence of sexual offences in the first place, and really tackling this harshly to try and make the services a place where everyone feels safe and included. In terms of the service justice system, we've got this overarching question of whether the service justice system is actually capable of independently and appropriately responding to sexual offences cases. And there's this idea that, you know, we've got a hyper-masculine environment which we know is potentially permissive of sexual offences. So if we're dealing with those cases within a justice system aligned to that, is that really going to be an effective option? That's not something that I can conclude on at the moment, and I think we need a great deal more research into the service justice system to actually understand that, but it's something that we need to consider going forwards. We also know that there's huge challenges faced by victim survivors in actually making the complaint and then pursuing that through the service justice system. So as I said, we've started to interview female veterans around their experiences, and we're seeing huge issues in terms of barriers to reporting and lack of victim support for those who do make a report. I hope to sort of develop on those recommendations, and as I say, if you attend the conference in December, then that's something that we will have findings of by that point, but it's something that we need to consider, and it's something that needs to be prioritised in terms of a victim-centred service justice system. And then finally, there is independent scrutiny at stages of the SJS. There's various sort of reports and evaluations going on, but ultimately these are all affiliated or conducted by sort of the government and the MOD and so on. So there's a need for further sort of independent academic research that's going to really interrogate these issues, and also to come together with people within the military and the government to try and co-produce some recommendations that we can come together and make effective recommendations for change. So that is us, and I'll open it up to questions.
Matt, Lottie, thank you very much. You have to excuse me, I think technology might be letting me down at my end, so if I'm intermittent on sound, you'll have to excuse me. There are no questions on the chat, but I've got a couple of questions. So from the research that you've been doing, has there been much engagement with the Service Prosecution Authority or the Royal Military Police or the generally? Have they been quite forthcoming in relation to providing you with documentation or providing you with comments?
Matt, do you want to start on that one?
Well, yeah, of course. I mean, I've got to say that, I mean, throughout all of the research that we do, what we try to do is to maintain a very good relationship with colleagues from the MOD and the Office of Veteran Affairs as well, because, you know, by maintaining good relationships is one of the ways that we seek to find change, as Lottie was saying earlier on. However, I've got to say, I mean, sometimes getting hold of the right information can be challenging. You know, sometimes we have to do Freedom of Information Act requests, and occasionally they don't work because they're either too complex or, you know, the information just isn't readily available. And I think, as Lottie was sort of saying in her presentation, that is one of the big challenges within this particular area of research interest. It's quite hard to join the dots up because information is held in weird and wonderful ways that sometimes doesn't really make sense, or can be sometimes a little bit opaque, I think is probably the safest way of saying it. So it's quite hard to get through it, but we do have good relationships, and certainly with the paper that, you know, we that that we recently wrote looking at prosecution, the differences between the civil and the criminal and the forces justice system. We had colleagues from the RMP that were very happy to help us and make sure that actually what we were writing about wasn't completely off base, because we're not from the military, we're independent academics, and we have with working with the military, we need to understand and talk their languages as well. So we need to make sure we're getting it right when we're talking about it, otherwise we'll just be sort of kicked into touch as not being relevant. So if you pick that up, Andrew, you seem to have frozen on our screens.
I did all of that. Thank you. So your conference, you say that's in December?
Yeah, it's on the 13th and 14th of December in Cambridge, okay. And it's a military sexual violence conference. And for the keynote speakers, we've got Dr. Sunella Durson, who is the chair of the NATO Research Group on Sexual Violence and also the director of research for the Canadian Department of Defence, as well as Kate Davis, who people here may know, who is a NHS England Commissioner for the SARCs, as well as Veterans Healthcare, and she'll be talking about this issue as well as some other really interesting people. Professor Daniel Perkins from Penn State is coming over to talk about the American experiences. We've got a whole series of workshops as well that are looking at this from various angles, including looking at sexual harassment within the NHS, which should be an interesting bit of work with some colleagues who are junior doctors, women junior doctors in the NHS.
Sounds really interesting. If what we can do is put details of the conference out and the documentation we send out today. Yeah. If you're happy with that, we can put links and one or two things on there if that works for you guys.
Yeah, no problem. Still, we're currently just finished finalising the information for the conference, and we should be getting out in the next week or so. So if I can send it over to you, Andrew, I'd appreciate if you could distribute it amongst your networks. That'd be fantastic.
Oh, great. Matt, Lottie, thank you very much indeed. That was really insightful. I'm grateful for your contribution today.
So what I'm going to do is I'm just going to introduce you to Kate Parkin, who works for the NHS. I think she's based in Sussex. So are you okay for me to hand over, Kate? I think you might just be on mute.
Okay, can you hear me? Yeah.
Yep. Hey, perfectly.
Perfect. Thank you very much. Thanks, Kimberly. My name's Kate Parkin. I'm the Director for Armed Forces Community. I actually cover Sussex and Kent and Medway. I work for the Integrated Care Boards now. And I do work though UK-wide, and I'm lead for some things in the region. So I have quite a lot of experience, but back in 2011, and I think this is really important, when I first started, I was NHS through and through, did not know anything about the Armed Forces community other than having a few relatives who were actually in Army, Navy and Air Force, but I wasn't directly related to it. And so I've had to learn quite a lot over this period of times, over this 12 years, and I'm so pleased to see how things have changed. And people like Matt and his team, it's been really good to see how they have influenced and done the research, because when we started, there wasn't really much to tell us what we needed to do, how we should be doing it. And so we just worked with the community right from the very beginning. As a team, we said, okay, we cannot deliver what we need to do on mental health at that stage without actually having everyone around the table. We needed people from the Armed Forces community, whether it was regular reservists, our veterans, our family members right from the start. And also we thought we can't deal with someone's mental health if they've got debt or they've got housing problems. So we've always been holistic, looking around that. And so things have come on there, and things have changed also in what's happening in the NHS. And I'm just going to take you through some of those, but also how that there's still things we need to be doing. This is just a quick slide reminding you of all the national systems that are out there now. We've got the Office of Veterans Affairs, who's been mentioned quite a few times today. They've got a strategy and an action plan, and there's some specific things in there for the NHS and for other organisations, which we are working through and making sure we are delivering in our area. Alongside that, you have the Armed Forces Forward View, which has been written by NHS, which has also got some key requirements and recommendations for us as integrated care boards and systems to deliver. So it's really important that we do think about those and work through those. The Armed Forces Act is really helpful for me because it's really changed things over the last year. It's put the armed forces in the heart of what we have to do within the NHS. Instead of being, yeah, we'd like to do this, yes, it's a covenant and there's a promise, it now puts it into a different light. Due regard means that we are having to think about it as part of the mainstream. We have to think about it in all the policies, procedures and everything we go through. And so that is making a big difference. Those of you not aware, there's the Veterans Dashboard, which we look at to make sure that we can look at things and see how we're doing and where things are moving forward. And that will just develop over time. And that's on the Veterans Office Affairs. There's 4 key accreditations which are relevant for the NHS, and these are really important and they will take time. It's not overnight that we'll get everyone there, but we're working through across the systems to make sure our GP practices are veteran friendly, and their first aiming point is to make sure there is one per primary care network. So that is in a region, a small group of practices, usually about 5 or 6 practices make up a primary care network, and we need to make sure they're veteran friendly. And that means that they do ask that question of their patients, understand who they are and know what to do with them. What we are finding is once you get one signed up, quite quickly a number of the other practices in that primary care network do sign up because they see the advantage of it. Veterans Aware accreditation in hospitals, and that's now expanding into other settings like hospices, is really important. Ambulance services, because that starts making sure, are the staff looking after themselves, thinking about their own staff, what they do, how they employ people, but then how they're looking after patients. But for me, I don't want someone to become veteran aware if actually some of their basic care, and that's the same with both of those, aren't up to the standard we would be like any patient to go through. So some of it is also making sure that all hospitals are fit for purpose. The step into health, and the top one is all about the employer side, making sure that we are a suitable employer for Armed Forces community to come and work in, and that could be anyone, whether it's families or a veteran or a reservist. We need to make sure we give them that support, or cadets. So there is quite a lot we should be doing within the NHS, and I think it's a really good stepping stone for us to make sure that we get across. It is important that we all work together to deliver that. I'm really pleased as an organisation, our integrated care boards, we've got our gold employers recognition, and actually we're going for revalidation this year, and it's really heartened me because of the Act. We're now getting it literally in orbit, like all our equality and impact assessments. And there is guidance that goes alongside that, the statutory guidance. I'm pleased to say myself, my team are in there because of the things that we do for training and development. And it is important that people do have that full understanding. It is holistic. And I think this diagram really does show that we do need to be thinking about that social economics, their education, the funding, as we heard earlier, making sure that people are getting the entitlement that they are due for if they've been injured through service. That comes up into that physical bit, the housing, and also for me all the addictions that go along the general healthcare. One thing to note within it, the third sector are not within scope of the Act, and so we do try and ensure that people are starting to put those still in the contracts, so that any services they discharge out of the NHS or local authorities are picked up as part of that. This is a bit of a busy slide, but the purpose of it is to start showing you how the Act now is impacting on everything we do. It's so important because it shows you that actually we need to be looking at our population health. Any of these research reports that have been done by other teams, we pull into now and will be part of the joint needs assessments that are done within our systems. Also, we are now making sure they go into the population health data so we can collect all of that together. That should all lead into all this policies and strategies that are being delivered at the moment, and also into the operation plans on how those are delivered. And so we will make sure that is in there, and that continues into the commissioning and then how the services are delivered. The NHS is the biggest employer, and so however hard we try to make sure all of these areas that are up there do take into account the armed forces. When some organisations have 27,000 employees as part of it, it is hard to get through there. And there are ways that we try to make sure we pick this up and that there is a support mechanism out there, a safety net. And that for me is a single point of contact, but I'll tell you a bit more about that in a moment. We're trying to make sure inclusion, that people understand the armed forces community. And as Craig said earlier, it is a very diverse group that is within the armed forces, and so everyone needs to understand the different requirements that actually when we talk in the NHS or the LGBT plus community, actually the armed forces experience may be different to the civilian population, and so we need to think about how we reach them, how they get included, so that they feel that their needs are being looked after. We have in our area a lot of Gurkha Nepalese community, and do we have the right skill sets within the NHS and other organisations to make sure they get their full support? We do have some specific services like Op Courage, which is for the mental health, which is been re-procured, and from the 1st of April the structures will be very slightly different. In the southeast it all will come under Berkshire, so that is the whole of the southeast area, Bob, which is the Berkshire, Buckinghamshire, Oxford area, down into Hampshire, into the southeast, Surrey, Sussex and Kent will all come under one Op Courage, and in our area Sussex Partnership Trust will be delivering the for Kent, Surrey and Sussex, but they will all be under the Berkshire Trust. So that service will now be fully integrated and linked in. You've got the Veterans Trauma Network, which is for all physical health when it's service related, and then all of these services have NHS England's input, and I'm really pleased to see that a lot of work's going on in a number of areas. As you heard from Matt Fossey's team, is they're looking at what happens for women, sexual abuse, all sorts of areas like that are being pulled into, maternity. So where people are being disadvantaged and having impacts, that these are all being looked at, and I think there's so much greater understanding for the armed forces community than there was 10 years ago. It is very different. And what's really also pleasing is some of the work we've been doing as a team and in the wider community is also feeding back, and people are trying to prevent it happening when they're within the armed forces. So that resilience has been built up and understanding to try and prevent some of this. So a little bit more about single point of contact, because this is fairly new and many of you may have not come across it yet. The single point of contact, the name is about to change. We'll be doing a big public launch and NHS England will be leading on that. Our pathfinders at the moment, there is one per region that's been rolled out. The first 3 were us in Sussex and Kent Medway, and we support the southeast. There's also one in Hertfordshire, and there is one round Catterick barracks, but actually there's going to be one in all areas except from the south west, because the large numbers are going to have 2. And we pick up anything, but the main focus is on families and carers to make sure that they are being considered and any issues are being picked up. And that's particularly where people transfer, because I've come across cases where someone has had to wait 9 years to get a child seen in the children's mental health services, because every time they've got anywhere near the top of the list, they've moved, and that hasn't been taken into account when they've gone to the next place. So we're now intervening in many of these cases, making sure that the trusts have an understanding that this is an armed forces person, if it's a veteran or a family member, and they must be taken into consideration. And also some of the complex cases we're getting through at the moment. We're getting a lot of complexity where actually the parent may have PTSD having served, and that is both male and female who have served, who may have issues, other physical illnesses, and then that impact then on their children. So we've got a number of families and children who we're also having to support get the required services. Some of them may have behavioural concerns, issues, need SENS support, which has special educational needs. So we've got all of those sort of really complex cases. And I think what's sad is, in one respect, is that they are needing to come to us for support. But what's great is they actually know where they can come to get that support and make sure that they're getting all the services that they require. And I think that's where things are changing, because people are suddenly realising about those families, and it's really good to see what's coming through. We will liaise with, as we said, other organisations, make sure that continuation of treatment. And one of the things we're always encouraging people to do is, if they're going through a treatment, get that referral in, even if they're going to be moving in 2 weeks. At least if they've got a referral, it's much easier for us to transfer referral from one place to another than to start through and try and fast track from a beginning point again. So everyone must be encouraged to be referred into any treatment that they're needing if they are serving and moving around. There's a lot of work also going on the social prescribing side, making sure that people have that understanding and actually use military charities and other ones as a place to send and get the support for individuals. It doesn't just have to be civilian charities that are supporting those sort of works. We've got a network of service champions across the UK now, so we can go to most organisations, speak to the service champions that we've trained and get them to support someone if they're moving from one area to another. Also, we'll provide professional support to those service champions who will come to us and say, what can we do about this case? How can we support? And it's really good because we've got DWP who are now supporting people. I've got service champions across the whole of the UK, and anything that is to do with financial or any side like that, we will get them referred in, and they'll very quickly pick them up with their specialist armed forces person to make sure they get the support they need. So that's where we've got multiple systems working together, whether it's NHS, care from the local councils, and all the SEND teams, and then you've got DWP, alcohol services. So it's actually becoming a big network across the system, and that's where things have changed over that period of time. Some work's happening with maternity at the moment, because it's been a known issue that often when people have been within the armed forces, then they go home to have their baby. How do you get the transfer of continuation of those services? Also, if they are moving around from one area to another, once again, you don't get that continuous service, and often they need to do it immediately and not wait to even be registered with the GP when they're moving from one place to another, or they may be under the Defence Medical Defence Medical Services, and so therefore how do you change them from that into a civilian GP and make sure that the care is transferred over? So it's things like that that we're linking in with and have got real live cases. As you expect, dental services is one of the areas that we have a bit of issues with, because actually over the whole of UK it's really quite difficult, and so we try and work with them and get them into cares and give them support into understanding how the dental services work, how best to get in. And we will also support cases where they may be injured and that's impacting on their teeth, and therefore they really do need to go through it, and sometimes we'll get the GPs to help refer them into the orthodontic services, as they can't actually get a dentist to be able to do that. So for me, it's reminding everyone there is help for all. We do a lot with the safeguarding teams in our area, because actually they are at the front end, being with the community, whether it is going, as we heard earlier, police into someone's home where they've been a victim of sexual or violent or domestic abuse. And so it's in those sort of situations that we try and make sure they're linking, that they're trained to ask the question to find out whether there is anyone from the armed forces in that, because that could be a really early intervention to get maybe possibly mental health, alcohol support for those individuals. There is a lot of support also with Project Nova, which is something that's NHS England is funding, and they're helping those who are going through prison services, and they're also the linking in with the various charities. So it really is multi-agency now, working with care for people. Like you've got the Care After Combat team. For children, there's the Thriving Lives, and so we're doing a lot of work at the moment with our children nurses, making sure that they have that in the education environment, so they also think about the health and well-being of individuals and start questioning, because even in an area, for example, for us, East Sussex has not got any regular bases in it. We know that about 40% of the schools still have people from the armed forces community and regular children in their schools. So that is really quite large numbers. So we do a lot with the safeguarding, also looking at all the substance misuse, also addictions, gambling and those aspects, to make sure that we're trying to keep the community safe if they require it. Families, as we heard, we do a lot of them, and the impact of others, because we're finding that we're actually getting quite a lot of partners who are needing to have mental health support because they've been impacted by the serving personnel who's become a veteran and maybe having PTSD or other issues. So it is impacting on others. Suicide prevention, we've got our SERVS training and a whole load of resources if anyone ever needs them, which helps you care for and ask questions and talk to people. And that's the biggest thing that's making an impact to this community, is that talking to people. We know directly where that has saved lives within this community. And we're working now and linking in with Help for Heroes, and recommend that anyone does their e-learning that they've done on that topic. So if someone wants just a quick intro, do go to what they're doing. I do like to remind everyone also within the NHS and work with them, is that there is a duty to refer, particularly if someone's going to be homeless. We must refer them in to the councils to get the support, to get housing, because there should be no veteran who should be on the street unless it is their choice. There is now a toolkit, there is central support for them under Op Fortitude, and also the councils need to be doing their bit. So it's really important that we pull all of this together and work together to do that. There's lots of fact sheets and support out there, so if anyone needs any of those, we've got some specific ones like on maternity, women. We've kindly worked with Craig to do the LGBT plus fact sheet, so it is there for anyone that they wants it. We have things like I am cards, so that allows people to go to their GP and say, I am a veteran, I am a family member of someone who's serving, so please pay attention. And the new card not just has the NHS Constitution on it, it has the Armed Forces Act stating that people must pay due regard to those individuals, and that starts empowering the individuals to say you've got to do something. And I think that's really important on there. You'll see that we really encourage people to use the research sites to go forward. There's lots of e-learning and getting that understanding, and I think that's really important. And I think there's been a lot of development since the Act comes in, and one of its requirements is that all staff need to be trained. There has been a much greater take up and that understanding of it. So we're coming to the end of my session and allowing for questions. So key things for me is a single point of contact. We've got really complex cases in there at the moment, but we've also got some simple ones which can be easily resolved. So it is there to help anyone. So if anyone comes across someone who's having a struggle with the NHS, doesn't know where to go, please do come to my team. We cover the South East, but we know the teams across the whole of the UK, and so can get you that support that's required. We also recommend people download the Armed Forces Connect app, because on 4 clicks you get your local services, and we're finding that everyone's finding that really useful as an app to get to. So thank you very much everyone for your time. Hopefully that's been a little bit of interest. There's a lot going on at the moment. The NHS has changed over those last 10 years, but I'll say it's got a lot more to do, and I can think we can learn from all of the other organisations on that diversity, inclusion, and how we make sure our environment is good for our staff within the Armed Forces community, and also that we do look after our patients with a bit of understanding and move them through. But there is now safety nets as well as the system changing. It's a bit like a ship. It is quite slow to turn, but hopefully it will start speeding up. Now it's pretty much turned. So thank you very much.
Brilliant, thanks Kate. Very informative presentation, very helpful. Obviously we can't thank you and your teams enough for all the support that you do provide to our service leavers. I know at Irwin Mitchell we really value that relationship that we have with your teams, and I think particularly on the AFCS side as well, when we have those lines of communication, we can really see the impact that we're having on the clients and their families just by being able to put them in touch so much more quickly with the services that they need. So thank you. So I can't see that there's any questions for Kate, and I don't think that there's anything further in the Q&A either. If there's nothing else, then I just want to say a massive thank you to all of our speakers today for taking the time out of their busy days. We know that you've got a lot going on with obviously all the fantastic work that you've been telling us about and the campaigns that you're working on. Just wanted to say as well a massive thank you to our attendees. The slides and the full sessions will be available on YouTube afterwards. A feedback form is also generated and sent out to people who've registered, I believe. So if you can fill that in and return it to us, then we'd be really grateful. If anybody wants to post to their socials, then we're using the handle #AgainstTheOdds, as you know. And obviously you can follow us as well for any more information on any further events that we have. So in the meantime, if anybody has any further questions, then please don't hesitate to get in touch with us. So thank you very much, everybody.